PowerPoint, get everything going here. Thank you all for being here. I pride myself for being on time. And hopefully you can see the screen that you have in front of you. We are here. I don't know. I do these sometimes much longer than 3 hours. I promise you a break when we get about midway. Take about, I think, 10 minutes. We agreed 10 minutes to take a break. But let me go ahead and begin the process. So we've got a lot to cover today, and thank you so much to the Orange County Association of Realtors for giving me 3 hours to talk about a subject that I could spend 6 hours. And I have. I think you'll get a pretty good handle on it. So anyway, my name is Kevin Burke. There is my telephone number. There is my email address. I am happy to help you in any way that I can. Please reach out to me if there's anything that I can do. I've managed to turn out some very wealthy real estate agents in my career. I have 46 years plus in real estate now. And what I feel like I'm doing is I feel like I am paying back those people who helped me back in 1979 when I first got my license. So please, I want to help. Let me know how I can help. Okay. All right. So thank you to our Orange County Association of Realtors. I am a proud member there, and for making the presentation today possible. And so here's some credentials. I always love credentials. And so here's how this works. I'm a strong believer that awards are for things you've done in the past. I want to know, what are we doing today? Okay, so I have a broker's license in multiple states. I teach in multiple states. I teach attorneys real property contract law currently. In fact, I have a class going on right now. I was teaching in 3 colleges simultaneously, but I'm only saying that because I realized that I wanted to help people who decided that they were going to be in real estate rather than people that were just taking it for 3 credit hours or whatever. And so I want to help you. I really do. All right. So Realtor Emeritus, that just means I've been in real estate for more than 40 years, dues paying member. I've been chair of pretty much everything, but I'm a big risk management guy. And part of that reason is that I am a non-practicing lawyer. I don't give legal advice to the public, but again, I want to make sure that everybody goes home, as we say. So I got a chat here. Good morning. Yes, we are recording this. Thank you, Elsie. We are recording this, and let me see. That's the gist of that. Okay, good. All right. So let me see. Anything else in there? Nothing important. I graduated first in my class in law school. I got the American Jurisprudence Award in real estate transactions. You don't know what that is unless you're a lawyer. Anyway. Most all of my presentations may be found at Burke Real Estate Consultants, Inc. That is on my YouTube channel. So if you have trouble with that, you can always call me. You can always email me. I'm more than happy to set you up so you can get to that. I have quite a few subscribers, and I'm constantly putting content on there that some of it, I've had people call me up and say, wow, I watched one of your videos from 4 years ago. And I go, I didn't know I still had videos on there from 4 years ago. How to do open houses, how to get listings every time you go on a listing appointment, things like that. So I also have done things for the California Department of Real Estate. They call me in from time to time, and so I did do a podcast for them on legal matters and documentation in a real estate transaction. And again, I'm not a practicing attorney. I did this as a broker practitioner, and it was very well received. So again, that's right on the DRE website. I'm famous, I guess, right? Better than being infamous. So upcoming presentations. So today we've got you're navigating change, because it is a big change, and I'm going to tell you, for those of you that are newer in real estate, my hat is off to you, because you are just going to, you don't know what it was like. And I'm going to show you today a little bit about what it was like. And you're going to realize that I'm glad we have what we have today. And of all people that should be resistant to change, I think 46 years, I'm changing every day. There's so much cool stuff out there. So today we're going to talk about buyer representation agreements. On the 22nd in September, holding a successful open house. I've been doing this on Zoom, but OCAR has been nice enough. They said I've graduated to where I can actually come in person and do it. So I will be doing that apparently at the Fountain Valley. Thank you, Elsie. The Fountain Valley Orange County Association. I will be doing that class in person. I think that's on a Monday. I'm not positive, but that's in September. Okay, so I'd be excited to see you all there if you can come in there. I assure you, if you've open houses are one of the easiest ways for you to make money in this business. And I just finished for OCAR. I just finished a webinar on the subject. And if you can't make money off of what I told you in there, give me a call. I'll help you out. I really will. And then finally, navigating change again, your guide to the buyer representation agreements will be 26 September. That will be back on Zoom again. And then finally on the 14th of November. So if you haven't had enough by then, lots of this stuff. And I know if you'd be really nice to me, OCAR might ask me to come back again, and hopefully I'll be able to do more stuff next year. Okay, so that's the good news. And I have an ongoing podcast, by the way. It's called Coffee with Kevin, with a K, Coffee with Kevin, Wednesdays at 4:30 p.m. Pacific Standard Time. Okay, and we usually run about an hour. This week, tomorrow, I have a special guest, Jesse Lipscomb, who is an enrolled agent, a tax advisor, and he is going to be going over the tax implications of the new big, beautiful bill and what that means to real estate agents and how to do financial planning. And he's just an awesome guy. He's just so good at what he does. West Point grad, super, super guy. And so he'll be there tomorrow at 4:30 if you can make it. Anyway, how do you get there? You go to the bit.ly link. So it's bit.ly/coffee with Kevin. And so again, I'm going to slow down a little bit because I don't want to overshoot my defenses, as we say. We have a lot to do, but I think we can get it covered okay within the 3 hours. So let's see how that goes. So we're going to be talking about things that appear to be legal. All right. I mean, you can't help it. You're in real estate. You're going to be having conversations with people that are going to be start to sound like legal stuff. And it was interesting because I was talking with a former commissioner of real estate, Wayne Bell, earlier today, and probably one of my favorite commissioners. And his comment was, attorneys doing real estate, they have to have a separate broker's license in order to be acting as a real estate broker. And so I made the response to that. I said, and vice versa. If you're a real estate agent, you have to be an attorney in order to give legal advice to people. So this spins both ways. And so that's part of my moniker here is I'm not a practicing attorney. I want you to know that. I can help you because I am a broker practitioner. I spend a lot of time in trial, testifying again as an expert witness. So standard of care is my specialty, and I do this all over the country. I have cases here. I've got cases in Virginia. I got cases standard of care. Did the agent do what they were supposed to do? Regardless of the outcome, sometimes we get stuck with things. But agents' duties of inspection and disclosure, and then finally market conditions in Southern California. So again, these are my subject matters. These are my topics that somehow somewhere along the way I'm considered an expert. Okay, so that's the deal. And again, the expert is a title. Okay, so I don't think of myself as an expert, but and again, the Department of Real Estate says don't call yourself an expert unless it's in a title. So expert witness is what I am. Okay. All right. So our conversation today is not intended as a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. And I want to make that very clear that I'm going to be telling you all kinds of really great stuff on how to do your business and all that kind of stuff. But if your broker tells you to do something in a certain way, please follow your broker's advice. And I say that because your broker is there to defend you in the event that something goes wrong. And so, again, if I say something that you have a question about, please put it in the Q&A field, and I'm gonna highlight that in just a second here. But please consult with your broker, and as clearly if your attorney tells you something, or you can have your attorney call me or your broker call me, and I'm happy to find out how they're doing. Okay, so our webinars here are intended to be interactive. All right, so please utilize the Q&A button to ask questions or offer input. I do look forward to hearing from you. And so sometimes the input that you have that you offer really spices up the conversation quite a bit. And so, I want to be attentive to that, and I want to make sure that I answer your questions. So, okay, that being said, thank you for joining us. That's the prologue, of course. Thank you for joining us for this discussion, Navigating the Changes, Your Guide to Buyer Representation Agreements. Now, we are going to go deep into the document itself. There used to be 3 buyer representation agreements. It was the BRE, the BRN, and the BRNN. And years ago, the California Association of Realtors merged the 3 of them together to make one document, now known as the BRBC. And I'm going to dissect that a little bit so that it makes it I think it's a little easier to understand what it is that it is talking about. So, and again, this is the impact from a broker practitioner perspective. In other words, I'm a practicing broker like you. I do real estate every day. This is what I do, and obviously I'm a practitioner as well. So, and I put this up here. This course has been submitted for renewal. So this, I want to make it clear. This course that we're in today is not for DRE credit. Okay, I am approved to do DRE credit, but we are not advertising this as DRE credit, and we are not following the pattern that we need to follow. It is. I do have a certificate from the Department of Real Estate that says that I am approved to teach a DRE class. This is not that class. And in the meantime, I have also submitted this for renewal. And so, at some point, I'm hoping that OCAR will give me an opportunity to teach it for continuing education credits. So you're getting it without the stress, right? You're getting it without the tests. Okay, I've got tests that I give you and things like that. So and as you saw a few minutes ago, I was teaching college courses in real estate for 15 years, and I just decided that I got tired of taking tests. I wanted to start giving tests. So that's why I just kind of did the role reversal thing, and we'll talk a little bit about that today as well. So we are talking about the Department of Real Estate on this page, and they have it in front of them. I expect that approval to come in any day now. They seem to renew mine pretty quickly. So, okay, that being said, let's talk about some ground rules. All right. And again, I don't want to overshoot my defenses. So let's see here. So by virtue of you having a real estate license, and this is direct contact that I've had with the department. So by virtue of you having a real estate license in California now, the DRE allows you to explain the standard forms. Now, why is that important? Because you're not here to give legal advice. And again, for those of us that are newer, that's like, at what point I don't want to get in trouble, right? But no, you have the ability to explain the standard forms. Now, and the DRE says that it's okay, not to do a legal analysis, not to interpret them on a legal bent. But I get people who ask me like the liquidated damages provision. And again, I teach this to attorneys, but the liquidated damages provision, it's like, what does it say? And I've had clients who have said, what does that paragraph say? It's in bold print. Anything you see in bold print, watch out, okay? Because that means you need to take that really special. You need to think about that before you start talking about it. So the way I always explain it, and I know what it says, right? I know because I teach it. But I always turn the papers around. I say, hey, let's take a look at it. Let's read it together. And so when I'm with my client, I'll have my client read it. And I'll read it along, kind of like in 2-part harmony. And what's really interesting to me in all my years, they come back and they go, "Oh, okay, I understand." Otherwise they need to talk to an attorney. Okay, and again, I'm not that attorney. So everybody good with that so far? Are we okay? So DRE says you can explain the standard form. All right. So and then the California Association of Realtors has a really cool document called the Use of the Non-Standard Forms Advisory, which I think you should get into the habit of when you're involved in a real estate transaction. And again, I do everything off of templates in zip forms. But when you get into a real estate transaction, you might want to have that form handy when somebody sends you a document that you're not familiar with, because it's not a CAR form, right? A standard form. And so, you might have to have that document ready, have that signed by your client. I usually like to get that done early in the transaction so that they understand, I can't give you advice when they send us over an affiliated business disclosure, for example. I can't advise you on whether you should sign that or not, right? Because I don't give legal advice, and it is not a standard form. Everybody okay with that? And we're going to see this is going to mesh into something really, really huge. All right. So I want to show you the purchase agreement that I started with in real estate back in 1979. Now, let's see if I can do this without hurting myself. But hang on a second here. I'm gonna pull up the document, purchase agreement. What did I do with it? Oh no, already my first snafu of the day. let's see, that's not it. Nope. This is my use of the non-standard form. Okay, so this is the whoops, can you see that? No, you can't. There we go. Okay, so this is the use of non-standard forms advisory form. This is the form I was mentioning that CAR created that explains some of the things that I just talked about, the advantages of the forms, the non-standard forms, broker's advice, all that kind of stuff. And here's why we got to where we are today. So here is the one-page purchase contract. This is the agreement that I used when I first got started in real estate. It was one page. All right. You'll notice it has different things in it. It's the real estate purchase contract. And I don't call it a contract. I call it an agreement. And all the forms that we have right now say an agreement. And the reason I say that is because an agreement is something we're going to put together and everybody's going to, coexist and peacefully get along and do the deal, much like my buyer representation agreement. But a contract is more onerous, right? Same thing, but the contract is more of something. I use that term when they're trying to get out of something, right? And so I say, okay, well, you might have to have that contract reviewed by an attorney, okay, because you have a binding agreement. And at that time, we were also, taking checks from our buyers, so it was called a receipt for deposit. And today, it says residential purchase agreement and joint escrow instructions. So very different document than it was. But I want to call your attention. Look down here, paragraph number 1. Did everybody see that? Okay, this paragraph number 1, and again, this is a one-page document. This paragraph is the reason we have 17 pages today. Okay. And part of that is because we were going in here and we were drafting this document up and we were definitely giving legal advice. In fact, at this time, Zip Forms wasn't out there, right? It was, we didn't have the ability to fill these things out online. We would print them. We had NCR paper. If any of you remember NCR paper, it's the old press down hard bottom copies yours kind of thing, right? And so I know I've got a couple people on this call today that know there are people on this call that got their license before I did. And I didn't think anybody was alive before I got my license, but Joe Kozora, who I just love Joe, he's been a broker for over half a century, and so it's like thank you, Joe, for being here. But this is what our one-page agreement was, and again, all this stuff, and I'm reminded that I've made all this available for you in the Dropbox account that OCAR will share with you on. I'm not sure if it's now or if it's when we're done later, but look down here in the lower left-hand corner, copyright 1971 by California Association of Realtors. And over here on the right, those of you who remember NCR paper, there's the indicia that says that it's NCR paper. Okay. So everybody okay with that? Anybody want any explanations on that? Otherwise, I'm going to close those two windows and free up some bandwidth here. So I'm going to close the one we're talking about right here. And then I'm going to close the use of non-standard forms advisory. And then I'm going to take us back over to moving along quickly in our PowerPoint. And let me see if I got myself right in the way. So from the current slide. So that was what it looked like in 1979. And because it was kind of the Wild West, as we say, the California Association of Realtors and the attorneys of the California Association of Realtors started taking the language that we were using. I know I saw some of my language showing up in some of the forms, and they were using that, putting that language and making it so that the attorneys were writing it, right, rather than us writing it. Because, I could have a conversation with somebody today and say, here's how I did it, here's how I do it, and then, talk to them an hour later, get a completely different conversation back. But that's how we were doing it. And that's why CAR got involved and started to create standard forms. Everybody good with that? Okay. So that's one of the reasons that today we have a 17-page purchase agreement. And frankly, I think I can't imagine it being shorter than that. I was here when it was 1 page, 2 pages, 4 pages, and then it went to 8. And everybody thought, no, we got to get back to 6. No, that never happened. It went to 10 and then 12. So, it just kept jumping up and up and up because we were adding in language to protect you, to protect me, and to protect the buyer and the seller. And today we continue to do that. Everybody good? Okay. So, and that's why there's over 250 what I call ancillary documents in the library as CAR, and I've created the packet for you. Let me pull this up really quick. I think I don't think I need to close out on this. I think I just need to pull up my. This is the distribution list. This is what you are going to get access to And here are all the forms numbered so that it makes it easier for you. Okay, so they're all going to be right in here, and I'm going to pop them up from time to time, but I'm not going to spend a lot of time on those forms. This class is going to be about the biorepresentation agreement. It's not going to be about the ancillary forms. And again, I teach the ancillary forms in other places. If you want, anything you want me to come back and teach, we're just going to drill through these things. And I do send out a publication every 6 months. Because we update our forms at CAR every 6 months, and I have a mailing list, and people get on the mailing list. They want to, please send me that. And so again, you got to send me an email if you want to get on the mailing list. I don't put people on there unless you ask to be put on there. So I have always held the position that if you know the buyer representation agreement, all right, if you know the BRBC, all right, then I think you know real estate. And I think that we focus a lot on listings and things like that. Remember that the buyer representation agreement is a listing agreement. Okay, why do I say that? I say that because it is listing the buyer, right? I mean, we always have the seller listing agreement to list the seller, but we also had the buyer representation agreement to list the buyer. And I was going over my notes, and I spent weeks creating this for this class. And I can tell you that going over my notes, I found classes I was teaching on this back in 2012. So, that's been 13 years, but I've been teaching this for almost 25 years since they came out with the form, because I'm a strong believer in it. And I'm going to tell you why in a minute. Okay. It's going to be really an important point. So how are we doing so far? There on my screen. Okay. I got everybody. All right. We're good. So, but I really think if you know this form, I think you really know real estate, right? Because it just covers almost all of the abnormalities. So here's our case in point. A written buyer representation agreement. It's not just a good idea, folks. It's in California, it's the law. Okay. And so I'm going to get into a little bit of history. I'm not going to go crazy on history because I've spent a long time here on that. But it's the law in California. It's California Civil Code 2992. Okay, that's the law. All right. If you want to look it up, bingo. I did not put it in your notes, but it's available for you. I'll send it to you. And interestingly enough, the Department of Real Estate recognizes the law, and that's what they're there to enforce for real estate purposes. But they're wrangling with language that's in the original statute in 2982. They're wrangling with language that's called "as soon as practicable." And so, why are they wrangling with that? And I've written papers for the department. Stephen Lerner, who's the head of education for the Department of Real Estate, and I, correspond back and forth on it frequently. As soon as practicable is what the current law in California says. If you're familiar with the NAR position on things, it's prior to showing property, whether physically or virtually. And so I was trying to get the Department of Real Estate to adopt that language for California, because remember, previously, they did not have a law that required you to have a buyer representation agreement. So what they really did when they created the new one is they just kind of copy and pasted from the seller listing part of things. In fact, in the original adoption, they forgot to change the words from seller to buyer. So those are things obviously that I pointed out. But anyway, as soon as practicable is causing a lot of issues for them because they want it done as soon as possible. And practicable, I think, is a word we made up at some point. But they want it done at the appropriate time. But I think we all understand clearly before you write the offer. Everybody understand that? Because you're going to see in a second, if you're writing an offer before you have a buyer representation agreement that explains your duties and obligations, you're probably giving legal advice, and we want to watch out for that. We don't want to be giving legal advice to the public. Everybody good? Okay. Questions? If you have a question, again, just remind everybody the Q&A, which is not showing up on my screen. The Q&A, I'm more than happy to answer questions in there. Oh, there it is. Okay, so it doesn't show up on my main panel. But anyway, please put your question in the Q&A. I'm happy to answer it. Happy to help you with it. Okay. All right. So remember that there are two parts to the agreement. And again, we're gonna go into the agreement. We're gonna go into line by line. But when you walk out of here today, you're going to know this better than probably most anybody. So, and maybe even a lot of attorneys. But anyway, remember that there are two parts to the agreement. So the first part of the agreement is buyer representation. Okay, so you're creating an agreement between your brokerage and the buyer, and that's the representation part. And and I'm going to quote Wayne Bell, later on in our meeting here today, where he had said, when you define your duty, you limit your liability, because we were talking at that point, we had a document called the BRE, the Buyer Representation Exclusive, and paragraph number 5 of that document laid out the duties and obligations of the broker. And that was our protection, because it said to the buyer, here's what I'm going to do for you. And I'm not going to do more than this, right? I can't, because anything beyond that's going to be legal advice. So that's why we both agreed that turn my phone off here. So we both agreed that if you define what your duty is, which is what that does, that paragraph defined the duty and defined your obligations to the buyer, then we're okay. We just don't want to go outside of that lane, as we say. Everybody okay with that? So interestingly enough, in my law class, I have the attorneys literally take the current buyer representation agreement, and I have them write out that paragraph. And if you send me an email, I'll share those notes with you. But they literally, they just do they type it. They have to type it out. They can't do copy paste. At the university, we've got software that checks for plagiarism and things like that. So they literally have to type it out, and it's like it's in So right now your document's got word wrap like this, but I have them do it, bullet point, bullet point, bullet point, and then they come up. And you know what they usually say to me in after the class is they say, "Wow, that was really thought that was going to be a dumb exercise, but when I finally did it, I realized you all do a lot of work for what you do." Okay, question, Quan, what do you consider standard forms? So a standard form, for example, this buyer representation agreement is a standard form, the one we're going to be digging into. Zip forms is merely the delivery mechanism, shall we say, to use another legal issue, is the delivery message mechanism for the forms. Those forms are created by the California Association of Realtors, and then they put them inside of zip forms, which we used to own, but we put them inside of zip forms so that you could complete them online. Okay, so that's my standard forms. They're all in your zip forms program. What about forms that some brokers require buyers to fill out in order to submit offers? Again, the buyer, in a lot of your question's a good one. In a lot of situations, the buyer is made to fill out a form that they're not familiar with, or that the real estate agent is not familiar with. We went through a lot of this when we had a lot of REOs, real estate owned, foreclosure properties and things like that, where the banks would come up with these crazy. I had one that was 64 pages long, and so the buyer says to me, "Well, what does it say?" And so I'm looking at it pretty much. Remember that the law is very clear that in order to be enforceable, it has to be written in plain English. So, it's kind of like air traffic controllers speak English, right? But, it has to be written in plain English in order to be enforceable. And so some of those, can you imagine 64-page form? And so my response was, you're going to really need to talk to an attorney about that. And so obviously I have a list of attorneys that I refer to, people that I am vetted with, people that I know what they're talking about, real estate specific attorneys. And even the California Association of Realtors coined a phrase now that's called the QCREA. It's the Qualified California Real Estate Attorney. So the QCREA, and we talk about it in the legal field a lot. And as you saw earlier, I was the chair of legal affairs for the state of California. And so, we refer to the QCREA, when we talk about, people hiring somebody to represent their interests, whether as a defense or as a plaintiff. And you need to make sure you hire a real estate attorney. So and I spun off in a direction here, but the standard forms are those forms that are created by the California Association of Realtors. And the reason your question is a good one, another reason, you've got a lot of good reasons that the question's a really good question. The other thing, I talk to brokers all the time, and back before it became the law in California, back in August of last year, before it became the law in California, actually, I'm sorry, it became the law in California January 1 of this year. But it became the NAR Code of Ethics requirement by virtue of the settlement, the Sitzer-Burnett settlement we'll talk about in a second. That became the rule on August the 17th of last year. But before that, I would talk to people about the form, and they would say, oh no, I'd never have a buyer sign that. I spent decades trying to get people convinced that they needed to have a buyer representation agreement with their buyer. And we're going to go into that and how you can handle some of the objections and some of the pushback that you're going to get from people if you're going to get any at all. And so, well, and I would ask them, I said, well, why don't you use the form? And they said, well, it's not required. And they said, well, I would never sign it. And so my response was always, have you read it? And you know what? 99% of the time, they never read the form. And I said, can you give the form a chance? Can you at least take a look at the form, read through it? I'll help you, right? I'll help you go through it. Paragraphs. There's some things in there that okay, all right, that may be a 400 level kind of class, but I think it's pretty easy to understand. But it was 9 times out of 10, and in our office we require it. So it's like our agents don't know any different. They were getting these done 20 years ago. We were always doing buyer representation agreements. We always had a contract with our buyer, right, that defined our duties. So and Quan, another good question. Some builders of newly built homes would also have their own RPAs. They're not going to call them RPAs. We call them contracts of adhesion. Essentially, it's a contract where there's no negotiating, right? So when you talk about builders of new homes, they have their own contract. In a lot of cases, they don't want anybody using any of their stuff. So let me ask you a question. So if somebody hands me a contract to sign and it's not a standard form, so do you think that the developers have attorneys who write the forms to be fair and impartial to all the parties, or do you think they are writing the forms to be heavy-handed on the side of the developer, right? In case there's a dispute or some kind of a problem, they want to have that mechanism in place, right? So again, new homes, a lot of times the agents, especially in Southern California, you go into a new home subdivision and they don't want you to be the agent in a transaction. They want you to be the referral licensee. They want to give you a referral fee, and but they don't want you to be the agent because you get kind of in the way. And again, that may be a better position for you, not to be the agent, but to receive the referral. But again, when you get into a situation, again, talk to your broker, please, but also make sure that you advise your client that it is a non-standard form. Great question. It's a non-standard form, and they need to talk to their attorney about that. And again, I have an approved vendor list that we give to people that I think I've got about 8 or 9 attorneys on there that are real estate specific attorneys. And so if you want a copy of that, send me an email. Don't put your email in the chat because when this call goes away, I lose all the chat. So, but I want you to have it. I mean, I've got vendors in there, all kinds of people that we've worked with that we know are pretty good at what they do. So, we've had people come and go. We've had people that we've taken off of the list because of problems that were created. So, you okay with that? Did I answer your question? Okay, I want to make sure I address it. And Kwam, thank you very much for asking that. But you're absolutely right. Standard form. And by the way, you also mentioned zip forms. When I was started in California real estate, it was called WIN forms, and I was on the Standard Forms Advisory Committee for WIN forms for over a decade and a half, 2 decades, until we purchased a company called ZipForms.net, which was, I think it was in Chicago, and we bought that company because we wanted to sell our forms from WIN forms to other states. But we knew that they probably weren't going to use them if they saw they were coming from California. So we created another company called ZipForms, and nobody's going to tell you this, but we created another company called ZipForms. And so we kept a separation. We kept calling ourselves WIN Forms for a long, long time. And then we finally sat down and said, you know what's costing us $6 million a year. Our members, it's costing them $6 million a year to maintain a separate brand. So that was when we made the decision to go ahead and just make it ZipForms, for California as well. And that saved us all a ton of money. Okay, so that was good. Great question. Thank you for asking that. And again, please, if anybody has a question, please let me know. Okay, so remembering again, there are 2 parts to the agreement. There's the buyer representation part, right? And then there's the broker compensation part. And I think it's very helpful to understand the differences between the two and to understand the concepts by differentiating between the two. And so buyer representation, so again, I'm going to have a written agreement with the buyer, in order for me to call them a client. Now, I know everybody was calling them clients before, but you know what? I hate to tell you this, they weren't your client, right? And there's a lot of reasons they weren't your client, right? Because we referred to them as a client. And I'm going to talk to you about what the Department of Real Estate was doing. And again, they were aware that we didn't have a contract with our buyer, and we kind of got away with it, but it had to do with a legal principle that I'll mention in just a second. But you need to have a written agreement. So like when you go to take a listing with a seller, I assume you get a listing agreement with the seller, right? If you don't have a listing agreement with the seller, and you start advertising a property for sale that you don't have an employment agreement on, and both of these are employment agreements, the listing agreement and the buyer representation agreement are both employment agreements, right? And they have language in them, and hereby grants and employs, right? They have to have that language in there. And if you don't have that agreement with a seller and you advertise the property for sale, DRE says that's false advertising and intentional misrepresentation, and those are both torts. And you don't need to know what a tort is other than to know it's not a good thing, okay? And they're pretty quick about that, and it's usually going to be somebody that turns you in because they know you don't have an agreement or something like that. And again, remember that if the Department of Real Estate investigates you, remember that they have an obligation at law to investigate all complaints. So it just means somebody turned in a complaint. That's all. And hopefully you'll be able to defend that. And again, listen, I can help you until the end of days. I'm never going to help you, subvert the law, but I will help you with whatever it is that, with that, short of legal advice, depending on what you've got going on. So in other words, again, here, they weren't really a client, they were really a customer. Okay. And again, I teach this in several states. And so the individual that you're talking to is a customer until you have a written agreement with them, and then they become the client. And now you both have protections, one from the other, as well as the language all changes. And now, remember, when they were just a customer, things that you were telling them might have been constitute legal advice. And that's one of the reasons we want to have a written agreement with them that says, and that written agreement, the buyer representation agreement that we're going to dig into here in a second, is that document that says, I'm not giving you legal advice. I will give you real estate advice. And here's the limitations on that. And we're going to go through that, quickly here. But just remember that they are a customer until you get that documentation from them, and then they become a client. So I'm just going to remind you, fast forward, I just did this talk for Orange County a couple of weeks ago on holding an open house, and I did a great big breakdown of all the forms you need to take to your open house to solidify a relationship with someone or to make sure that you keep your distance from them. One or the other. You either want a contract with the person that comes into the open house, or you want to make sure that they understand that you are not giving them legal advice. You're not going to break the law, and so it's going to limit the interaction, and obviously therefore provide some indemnification, which is the big legal word that you'll get familiar with. Questions? Oh God, I love your questions. Thank you. 1, 2. Okay, that's okay. Good. Come on, I'm good, right? I got it all. Okay. All right. So again, they are a customer until they sign a written agreement, then they become a client. Okay. All right, good. Because we've laid out the ground rules. This is who we are, right? This is what your tasks and responsibilities are, and here's what my tasks and responsibilities are. So the second part of this is going to be the broker compensation. Now, you need a written agreement with your buyer. This is going to surprise a lot of people, but in order to get paid. Now, I think, listen, I give a lot of money to charity, right? I'm famous for, I give it out to charity all the time, but I want to pick my charity. So, when I'm working with a buyer, it's not charity. When I'm working with a buyer, I expect to be compensated for what I'm doing. And we're going to talk about objection handling and things like that in just a minute. I'm going to ask for your input on that, right? So, but in order to get paid, I have to have a written agreement, all right? So the DRE requires it. It's the law. Okay. And so, in fact, they always have required it, which is kind of a surprise to a lot of people. They think all this mush started in August of last year. No. This has been an ongoing thing. So those words that I hate to hear are, but I've always done it this way. And so I'm just going to ask you, like I did in my open house class, just stay with me long enough. Just, let's look at a different perspective on how to handle this. I will help you through it. You're going to know this better than anybody knows it. Okay. So in the old days, we were paid as third-party beneficiaries. We call it in law, we call them a TPB, a third-party beneficiary of a listing agreement, right, between the seller and the seller's agent. So how are we getting paid? We were getting paid because somebody else had a contract. Somebody else, the seller and the seller's agent had a contractual relationship with each other. And in that contractual relationship, it said that we, as the buyer's agent, would also be compensated. And we wrote it out in the agreement as to how much on the listing agreement, seller's listing agreement, how much it was that we were going to compensate the buyer's agent for, how much we were going to give them for representing their buyer. So now remember, you as the buyer's agent, you never signed any of those contracts, did you? Those were all contracts between the seller and the seller's agent. So there's this kind of weird fiction at law that says that you received your check as a result. And the Department of Real Estate looked the other way on this, and they had reasons why they did what they did, and not bad things. It was just trying to accommodate what we were doing, but the bottom line was that we were getting paid because of somebody else's agreement. Everybody good? Okay. I don't want to start to sound like a law class because I'm trying to avoid that. But again, I'm available for questions. And so, okay. So one of my former students, and so she created a representation of her understanding of the concept of the buyer representation agreement. She's now the broker for my company. She figured this out. She decided she wanted to get a real estate license. And so months after class was over, and I always tell people, it was months afterwards that she came to me. She said, "I want to make sure that I understand, what we're talking about." So she drafted up this document here, and I'm going to show you. Let's see, that's not it. That's not it. Where am I, buyer? That's not it either. Okay, what did I do with you, Linda? 3. Here we go. So this is what Linda drafted, and this was her explanation of the relationship at the time she was in class. Now, again, this was 15 years ago. Okay, since that time, well, I'll tell you about her in a second. But anyway, so this is what she created. She came to me and she said, "Is this what you mean?" And I thought, listen, I'm not an Excel guy, okay? So, I don't understand. She created this. I was floored, right? I said, well, I never thought anybody was really paying attention to me, but now here she drafted this. So on the left-hand side, you see, without a buyer representation agreement, at that time it was called the BRE, the Buyer Representation Exclusive. Without that, we had that third-party beneficiary. See that line going across from seller to seller's agent? Okay, or seller to selling agent. At that time, we called the seller's agent the LA, the listing agent, and we called the buyer's agent the selling agent. And it's kind of a funny story because the Department of Real Estate was aware that it was very confusing for everybody, and so they put it on state exam. So it was on the state exam. I remember because I teach the brokers exam in California and in Virginia, and in California the questions on the state exam were confusing. Let's just put it that way. So today, October of 2018, California Association of Realtors, created legislation to actually change the names from listing agent and selling agent to seller's agent and buyer's agent. Okay, does that make sense? Because why? Plain English. We're back to plain English again. Everybody knows what I'm talking about when I say the seller's agent, right? And so the buyer's agent, but listing agent and selling agent, everybody was always confused. Well, who's who, right? So you see that line that goes across at a diagonal on the left-hand side. So without the buyer representation agreement, because it was very well available, everybody could have used it, but they were like, "Oh no, I don't want to do that. They'll never sign it. I don't want to go work with somebody else." I had a million excuses, folks. Today you don't have a choice. Today you got to have one. It's just the way that the law works today. So, and frankly, because of, I have people calling me up saying, "You were telling us this 25 years ago. I cannot believe it. The whole law came your way." And it did. Which I'm kind of proud of that, but I've been advocating for this for a long time. So without the buyer representation agreement, right, then we were getting paid by virtue of somebody else's agreement with themselves. And we weren't a party to that agreement, except that apparently we could get paid because somebody else had an agreement. Does that make any sense? And then on the right-hand side, with the buyer representation agreement, and again, this is back 15 years ago, now the seller's agent, the listing agent, works for the seller, and the selling agent, the buyer's agent, works for the buyer. And then now you see that there's no line going across. But the hardest thing for me to do is to get people to acknowledge the fact that they did not have an agreement with their client until they did what's on the right-hand side of your page. critically important, right? And this is how you keep yourself out of litigation. This is how you just truth in advertising, the whole thing, right? Okay. And we'll talk about Sitzer Burnett in just a second, but I wanted to show you that. Everybody good? And again, this is included in your package, so you'll have all of this for when you get that from the association. So okay, so she's now the broker for my company. She just wouldn't let go. She just kept coming back and asking questions, and God love her. She's just really, she knows real estate probably better than anybody I know. And frankly, she went on to get her broker's license in Idaho and Virginia, and she runs corporations in other states. And so, and you know what? She's just a super gal. But I gave her my company. I said, here you go. I want to go teach. So, she's now the broker for my company. She's got quite a few agents under it. And her name is Linda Driley, in case anybody cares, but she's a super gal. I told her I was going to talk about her today, and she doesn't like that, but I don't care, right? Because she did a good thing. She figured it out. She wrote it down. The only one who ever did that. So those old days, the way we used to do things, are gone. Now we're going to enter the Sitzer Burnett antitrust decision. All right. So Sitzer Burnett was a huge lawsuit where, in fact, it started in San Diego. But and it got thrown out right in San Diego, and so they moved it, went over to Missouri to do it, or it was Missouri to do the lawsuit. They went over there because they knew they'd get a more favorable response, and you know what, they did. And so interestingly enough, I completely disagree with how they got to the decision, but I completely agree with the decision, and that is you have to have a written buyer representation agreement with your buyer. Okay, and so I disagree with how they got there, and for a lot of reasons that I'm not going to go into, but I completely agree with the fact that we're required to have a buyer representation agreement. And so I mentioned this earlier, those of you that are newer in real estate are going to find to be a huge benefit for you, because a lot of the people that have been around a long time are confused by all these changes, and they just have a hard time adjusting sometimes, right? So kudos to you. The money is in the novelty of what you're doing. Okay, so that's Sitzer Burnett, antitrust, the whole thing. And so it created a whole bunch of rules. NAR had to put together some rules. If you want more information on it, go to facts.realtor. We talk about it from time to time in my coffee with Kevin on Wednesday evening. Again, it's free. Come on in. There's no charge. Come on in and join us. But facts.realtor, you can get a whole bunch of information on the subject. So as a result of that settlement, NAR promulgated rules that applied to all realtors, because they couldn't regulate non-realtors, right? And so, but they could regulate realtors. They could say to realtors, all right, here are the rules you're going to have to follow. And it was a tough call. And a lot of people were like, how could you possibly lose that lawsuit? Why didn't you appeal it? Well, the bond required to post for the appeal would have bankrupted NAR. So, again, not to get too deep into the subject, but there's a lot of reasons why it came out the way that it did. Okay, so those rules applied to all realtors. Okay, and those would take effect on the 17th of August. Everybody good? The rule does not apply to all licensees, only to realtors. Okay, so be clear. All right, so that meant that non-realtor licensees in California and in other states were not subject to those rules. And by the way, they were also not subject to the protections that the rules provided. So, the lawsuit came out, the settlement in the lawsuit, ultimately the settlement said that in exchange for this, you agree to do that. And that's, that exchange of promises, the quid pro quo that you hear about, that the real estate community would follow certain rules. And so today there are law firms out there that are tracking real estate agents' behaviors, mostly MLSs, because they're looking for the big money, right? So they're looking for the big money. So they're tracking MLSs and their behavior and things like that. And you've got a brilliant attorney at CRMLS who's at the helm of CRMLS, Ed Zorn, super guy, and very bright. And so, we follow those rules, right? Because we don't want to step outside of the lane and create a problem for ourselves. Okay. All right. So CAR came along and quickly proposed, and then had it passed legislation that made the rules, most of them, apply to all California licensees. So whether a realtor or not. So again, they did that, and they did it in a hurry because they needed to get it together. They literally put it together right after NAR promulgated its rules. And I remember because I was in the board meeting, board of directors meeting, and I think it was September, October, and we had the legislation in front of the California legislators before the first of the year, and then they created the rule that leveled the playing field, made it, because we didn't want the non-realtors rushing in and taking advantage, so that, because I don't have to follow those rules, which I think was a mistake, but okay. And on the other hand, we just wanted to level the playing field, making a lot of those rules apply to everybody. Everybody good with that? So if you're not sure the distinction between the two, licensee versus realtor licensee. So there are approximately 424,188 licensees in the state of California as of last month. 185,000 of them are realtors. More than half of them, so you may be in a pretty good crowd here. More than half of the licensees in California have had a license for less than 5 years. Right. So I talk to agents all the time who say, "Oh, I'm retiring." I go, "Well, you haven't done a deal in 10 years." And it's like, "Oh, okay, I guess it's easy to retire, but all right." And yet I worked with a guy who was doing 822 transactions a year. So it's like there are people that are doing a lot of transactions, and most of them happen to be realtors. Okay. All right. So CAR has an excellent form that explains the distinction between the two and why it's beneficial to the public to use a realtor. Okay. So I personally believe you should be using this form in every transaction that you do. All right. And that's called the RA form. And so again, I create templates within Zip Forms, and the RA form is one of the forms that I always recommend that everybody have. Let me get rid of that for a second. I'm going to go to the realtor acknowledgement form. This is it. We changed it in 23, but it was a pretty cool form, and explains the difference between a realtor and someone who just has a license, a real estate license. And again, I use this because when I use this in a real estate transaction, I tell the person that I'm talking with that I am a realtor and I am bound by the NAR written code of ethics. And so they say, "Well, what about all those other people?" And I say, "Well, they may not be bound by that." Now, I mean, I'm not saying they're not ethical, but again, and I don't know who they're talking about. Some of them could be realtors, but some of them not. But I want them to know that I'm going to put it right down here in front of them. And I always have you sign this. You sign this in front of the client, right? Because there's your signature goes first, and then the client's signature goes second. And so I use this form, and part of this is my best closing form. All right, everybody okay with that? I mean, I use this form all the time. Every transaction, whether it's buyer side, seller side, whether it's commercial, whether it's industrial, doesn't matter. I'm going to use it in all those cases. Everybody okay with that? All right, so let's go back to my documentation now that I figured out how to do that. A realtor is held accountable to the written NAR code of ethics. A non-realtor is not held to that code of ethics. And, I may say it that way. I'm not casting dispersions on other people. I would never do that. Right. We have all different types of things that we do, and they may have a different business model than I have. So there are those that believe that this gives the newer licensee, the newer realtor, a distinct advantage. And I think it does. I think you have a distinct advantage because you're willing to embrace the change, right? Okay. All right. So prepare for your buyer consultation. I want to talk a little bit about this. So with the promulgation of the new rules, you have to have a buyer consultation. It says right in there, you may not show property either physically or virtually without having a written agreement with the buyer. And NAR says before showing the property, the law in California, which NAR governs what you do, right? So you've got to have this document prepared before you show property, whether physically or virtually. We're going to talk about, can I send them a list? And it's like, well, that's not going to protect you, but okay, we'll talk about that in a second. But you have to have the buyer consultation. No more showing up at the property. Somebody calls me on the phone and says, "I want to go see this house," and so I'll see you there. And what do? We drop everything we're doing. Kids are on the ground. We drop everything we're doing. We rush off to go meet with them. And you know what? That's a mistake. Okay, for a lot of different reasons. And again, I teach realtor safety, so I'm going to have to fix something here really quick. Now I have all these people saying I can't get in. So okay, all right. I'm sorry, I got to turn some air on in here. It was 101 degrees in my office the other day, so I have to fix that. So anyway, so you want to have a buyer consultation, and you need to have one. And so you need to set up ahead of time, what do you want that to look like? Here's my advice. My advice is get yourself I know, a legal pad, some of you aren't familiar with that, but get a legal pad, something you write notes down on. And so you need to conduct it to find out what's important to the buyer. How can you possibly show them property if you don't know what they're looking for? I never showed more than 3 houses, right? I mean, because, even today you've got to scrape through to find out which ones are still available. But, I didn't want to go out and show just one place. I would show 3. And they always bought one of those 3. I've never had to, because I did a really good buyer consultation. Folks, listen, I want to save you time. I want you to be able to close this down and get what your person is looking for. I could tell you there's a guy up in LA in Beverly Hills who's $20 million income a year, and he does a very good screening with the buyer. And now you have Zoom, you have all kinds of different ways to meet with your buyer and go through all this stuff. So you need to conduct that buyer presentation. I call it a consultation. It's an interview to find out what's important to them. And you're going to need to have it anyway in order to fill out the forms. Right? So you're going to have to fill out the form. I'm going to show you in a second. You can't possibly go show, I have people coming on, I want to go look at property. Okay, cool. We have 36,000 listings in the MLS. If we start today, we'll be done by 3 years from now. Right? But I'm not going to show you 36,000. I got other things to do. Right? So I want to nail this down to where I'm only going to show you a couple properties. So I'm going to show you how to use the form, right? We're going to get to this in a couple minutes, but use the form to create your buyer consultation. And so get your little legal 3x5 and start writing down the questions, okay? And make it look like a production, make copies of it, do stuff like that, and then take notes. You want to sit down with I learned very early in my career, back in the 70s, I learned very early that I would write everything down that they would say. Folks, this was some of the best advice I can give you, is write it all down. Why? Because you help them to feel like you actually care. Right? I know some of us are like, I can't wait to get paid. And it's like, no, that's not the deal. The deal is you want to care about what your client is doing, right? And what they're looking for. How are you gonna show them property on a distinguished basis? How are you gonna show them stuff if you don't know what they're looking for? And that buyer representation form helps you nail that down. It's really exciting that way. Okay. All right. So I'm going to cue Irene Young, and Irene knows I talk about her. She was I was management at Prudential, which was the largest brokerage in San Diego County for a very long time. And Irene was one of my agents. And I just love Irene. She was just real simple, not real complicated, kind of like Linda, not real complicated. But Irene would take them into the conference room. And I remember a lot of times I'd sit there and I'd watch her in that conference room. Folks, let me tell you something. She'd go into the conference room with them for 2.5 hours. Right? I would look at people coming in the door going, oh my God, you have no idea what you're in for. And Irene would take them into the conference room and she would sit down with them and she would spend 2.5 hours with them. And she'd have that legal pad I'm talking about. And she had this list of questions that she wanted to ask them. And she would go through each of those questions with them. I'd come in, I'd offer coffee. Sometimes I'd buy them lunch, because I knew what they were going through. But I assure you of this, that no one ever went around Irene. When you sat through her presentation, you definitely worked with Irene. Folks, you need to think about this for a minute, right? Okay, do you like losing people to new home subdivisions? Do you like losing people to my niece is going to write? She just got her license. Listen, I got tired of that. That's why I started teaching this, a couple decades ago. But Irene was a master. She would just go in there. She would ask them a bunch of questions, and she would write everything down. Right? Remember what I said? Write everything down, makes them feel like you actually care. And so she was writing everything down. I talked to Irene a couple months ago. First time I talked to her in like 25 years, 20 years now. And I said, I talk about you all the time. And she says, oh God, Kevin, I love you. I said, well, I love you too, Irene. But the bottom line is that, you're brilliant. I mean, the questions that, I don't know if it was the questions, but nobody ever went around Irene. They always worked with Irene. Okay. And I think part of that reason was because they thought, well, if I've got to go through this with Irene for 2.5 hours, I don't want to hire another agent because I might have to go through it again for another 25 hours. I mean, think about it, right? Kind of makes sense, okay? Jim, non-realtors, not member of NAR. Yes, a realtor is someone who is a member of the National Association of Realtors. So if your brokerage is a member of the National Association of Realtors, then all of the licensees within the brokerage, there's a couple minor exceptions to that, all of the licensees must also be members of the National Association of Realtors. And that's, we refer to that as the dues we pay, right? So I think I look at it as the cost of doing business. I think it's, part of the political situation that they help us with that. They lobby, they do all kinds of stuff. So yes, Jim, to answer your question, I want to make sure I'm answering it, but not someone who's not a member of NAR is a licensee, not a realtor. Good. If that didn't answer your question, please elaborate further. Okay, I want to answer your question, but that's how the deal works. Okay. All right. Okay. So Irene, loved Irene, and I use her as a model. And every time I teach a class like this, as what you should do. So you should sit down with the client, right? The more time you spend in that initial consultation, you're not going to have to come back to it again, right? And you're going to avoid 50 questions throughout the rest of your career with these people. You're going to avoid having to answer things that you should have answered up front. Right? Should have asked up front. Okay, so let's discuss some of the common objections to signing a BC. And this is where I'm going to ask you for some help. And we've got quite a few people on this. And again, the Q&A button is open, so please go ahead on in there. I haven't looked to see who's on this, but we have quite a few people. So let's talk about some of the common objections to signing it. Okay, so why would somebody not want to sign it? And again, it was a very different set of objections last year than we have today, okay? Because the rules change on that. You don't have a choice. You have to have a written agreement with your people before you show them property. Thank you, Jim. Thank you. I appreciate your courtesy. Thank you. So how much are you going? And by the way, when you ask a question, nobody can see your question, okay? Everybody understand? Nobody can see your question. So I'll repeat the question because I know you can't see it, and then I'll use a first name. I'll never use a last name. So I just want to make sure that everybody's okay with that. How much are you going to charge me, right? So my buyer representation agreement has a place in there for me to charge a fee. Now, we're not going to get into any antitrust, and I teach antitrust, so I know where I'm going here. We're not going to have a conversation here that's going to be questionable, okay? So how much are you going to charge me? The buyer says to me, what's the fee, okay? And that's one of the reasons, by the way, that CAR does not create their forms with the commissions already printed on them, right? And that's because the commissions are negotiable at law, okay? And we'll go deep into that in just a minute. But how much are you going to charge me? That's a big one. Anybody else think of anything that they get from people? Questions, objections? I'm going to show you in a second that you need to go for what you're worth, right? Unless you just like I said earlier, do charity. How long is it going to be for? You have control over that. You have control over whether it's going to be exclusive or non-exclusive, and we're going to talk about that. So, Rosanna, would non-realtors be able to use CAR forms? Well, there's some copyright issues there. And we go to great pains to prevent non-realtors from getting them. In fact, I can tell you that I work with a lot of attorneys, obviously, and those attorneys, they have to pay extra to get access to the forms if they are not realtor members. Right? They have to pay extra to get access to the forms. I have several attorneys that I have helped get their broker's license because they got tired of paying $1,000 a year for something you and I get for free. So they got their real estate license so that they could become a realtor, and then they got the forms for free, among other privileges and benefits that they get. If Davina, if you can't afford it, I get that, and I get that question, occasionally from people say I just can't afford it. Well, you need to kind of ramp that up. You need to start making some money. But again, you have several options. If you're a realtor member, you get the forms for free. If you're not a realtor member, it costs you even more. The risk that you take if you're using a non-standard form, and there's some groups out there that create forms. Again, talk with your broker about how to handle that. But if you use a stationary form, a form from a stationary store, for example, I can't advise people on that. And if you write an offer on one of my listings with a stationary store form, I'm going to tell the seller that I really can't advise you on this because it's not a standard form. So that's just some of the things that we're going to have to get used to. So how long is it going to be for? What if I want to play the field? What if the buyer says, well, I want to, work with, everybody until I can find somebody I like? Well, unfortunately, it doesn't quite work that way. I now have to pay you, my buyer's agent. Yes, before the sellers pay for the buyer's agent. So Quan's question is, now I got to pay you. I'm the buyer's agent. Now I got to pay you to represent me. And the answer is you've been paying me, right? You just didn't know that. And that was part of the deceit that came out of the Sitzer-Burnett, was that, California obviously dodged this rule. They had to go someplace else because California, we told the seller, here's how much we're going to charge you. And this was paragraph 3A1 of the listing agreement, of the old listing agreement. Here's how much we're going to charge you. And 3A2 was, here's how much we're going to pay the other agent. Right. And so, we told them about that. So there was transparency in our listing agreement with the seller. But you were paying for it. The buyer was paying for the buyer's agent's commission. Again, remember that TPB, that third party beneficiary, by the purchase price they were paying for the property. Right. And they were maybe not necessarily hiring good negotiators to try to get those prices down. So yeah, now you have to pay me unless I can get the seller to pay me. We're going to hit that in just a couple minutes. We're going to be on that. Okay, so I'm going to show you how to get the seller to pay the commission anyway. There's no law that says they can't pay the commission. There is a law now that says you can't put it in the MLS, right? Part of the settlement, I should say, that you can't put it, the commissions in the MLS. And if you try to be cute, like here's 3 bushes, this is the commission, think of this as the commissions, those are the kind of things that are going to get you a big ticket. So you don't want to do that. So sellers agents, the listing agreement, by the way, Quan, that you're mentioning, the listing agreement has no reference to paying the buyer's agent. There is a reference in there for the seller to agree to pay concessions, but those are not commissions. So, we'll talk about that because I'm going to pull the form up here in just a second. So, I want to play the field. I mean, it's kind of like speed dating, right? I'm not really interested. I'll play this. I want to go ask. They're not going to be able to find somebody unless they can find somebody who doesn't realize that there's a new rule. And again, that's why we have brokers. The brokers are there to watch what we're doing and to counsel us. But we don't need to play the field anymore. What if I don't want to sign one with you? Okay, fine. I'm going to go to the beach, right? I mean, if somebody won't sign the agreement with you, maybe they're just telling you that you haven't established rapport with them yet. And so, I had an agent when I was, again, management at Prudential back 25, 30 years ago now, comes in my office and had a buyer representation agreement signed. And I looked at her and I go, how'd you get them to sign this? And she says, I just put it in front of them. They signed it. Okay, well, I'm going to tell you, you should probably be explaining what it is you're asking them to sign. But, it moved forward. It turned out I met the buyer, went through the whole thing with them. And oh, thank you, Amherst. Thank you. It's very kind. But the agent, and she was just awesome. I mean, she goes on these appointments and they sign everything. And, so I said, did you explain these things to them? Well, sure I did. I'm like, okay, here we go. Right. So there's that your word against mine kind of thing. But, God love her. She did great. Brand new agent. She was just wonderful. So, I want you all to do well, folks. I want this to be a panel full of millionaires in a year. Okay. But if they don't want to sign it with you and they tell you that means you either haven't built rapport, but remember that agreement cuts both ways. Think about this. You create an agreement between yourself and the buyer because you're thinking, I want to commit the buyer to work with me and only with me, okay, if it's an exclusive agreement, right? But that sword cuts the other way. And that's why I'll tell you, some channels, I don't like long buyer representation agreements. We're going to see some limitations on it anyway. But listen, that sword cuts both ways. I want to make sure, do I want that buyer? And I have this conversation, this deep down heart to heart with a lot of agents, give it away, give it a referral, give it to another agent, somebody else that can work with them. And I sometimes massage that, today, I mean, with people that, we're just not, I had one who was the PhD in psychology. She was the broker, was a PhD in psychology, and she just couldn't get along with this buyer. And so I referred it over to another broker who paid her a pretty healthy referral fee because she says, I just can't figure these people out. I don't know what's going on. And you're a PhD in psychology. So, but that other agent, by the way, it was with my office and is still today after 20, it was one of my students back in 2003 at UCSD. So, okay. So anyway, understand that some of these people you may not necessarily want to work with. Don't be afraid of the question, right? Because what? They're going to ask you about commission. That's the big deal. They're going to ask it. They think they're supposed to. They don't know what else to do, right? And so, how much are you going to charge me? And I'm not going to tell you how much to charge. And your broker has an obligation at law to establish a minimum commission within your office. And any conversation outside of that gets into price fixing or anything like that is just not going to be good for any of us. Okay, but your broker has to tell you how much is that. Check with your broker. So most times when they ask you about it, it's just a question. All right. So let's present our value proposition. Let's go. Remember to distinguish myself from the rest of the pack. So, that's like, listen, we have how many licensees we have? If I look at the MLS data, I probably got about 20,000 maybe MLS participants in San Diego County, for example. And if I include Orange County and Riverside County, I'm probably running a fairly good number. So what is going to make me different than the rest of it? And I had this conversation with an attorney yesterday. I go on the appointment. Right? Not everybody goes on the appointment. As management, I get those phone calls that said, your agent had an appointment with me and they never showed up. I can't even conceive of that. So, but we get that, right? So distinguish yourself from the pack, show up. Most of the times they're the ones that are going to get the listing, the ones that actually showed up. Okay, so Jim, commission versus compensation. Very good, Jim. Thank you. If I've been misspeaking, we don't say commissions anymore. We say compensation. So commission is what the broker receives. Compensation is what you receive. Okay, so good. Thank you, Jim. Excellent. Do your top 10 things I'm going to do for you. When you have your buyer consultation with them, go through a list of here are the things I'm going to do. Back when I started in real estate in the 70s, I worked with the gold people. And we had 21 things we'll do for you. I used that as a great closing tool back then. We didn't have an RA form, right? And so I would write down here's all the stuff I'm going to do for you. And so they would look at it. I'd make them sign it, right? It wasn't binding contractually or anything at that time, but I'd have them sign it. And so, and they would realize, okay, we're getting something, we're getting some bang for our buck here. Okay. All right. So take notes from your listing agreement. We're going to talk about the buyer listing agreement, the BRBC. We're going to hit that. We're closing in on that here really quick. So prepare for the objections. So-and-so will charge me less. Your response, and they probably should, right? They can't compete. They have to compete with me on price because they can't compete with me based on service. You remember the old saying, you get what you, and then I always recommend you wait and let them fill it in, right? So pay for, let them complete it because then they own it, right? So if you're doing all the talking and again, we're in a lecture right now, so I'm going as fast as I can because I have a lot to cover. But when I'm sitting down with a client, Linda will tell you, when I'm sitting down with a client, I'm a whole nother guy. And most of my clients are attorneys, and I'll sit down with the client, we'll go over stuff. And she says, God, you ask a lot of questions. I go, yeah, right. And at the end of the day, they think I know a lot, right? Because I ask a lot of questions. Okay. So you need to ask a lot of questions. All right. So I hear the commission in the market is at such a figure. How do you know that? I mean, how do you know how much, we had an offer we presented on a property up in Wildomar the other day. And the agent came back and said, what do you mean you want this much commission? Everybody knows everybody around here only gets this commission, which was considerably less. And I said, I don't know what everybody else gets. And I think that's an antitrust violation to even have that conversation. But they were convinced that everybody, that's all they were getting. And it's like, well, maybe that's all you were getting. You were having your seller offer them. But that's our business model is different. That's all. So how do you know? I mean, you can't know. Okay. So-and-so has a lot of listings. I promised you personal service. So would you rather hire? So this is where you have the seller's agent who would like to represent the buyer. And I always say to the buyer, would you rather work with the real estate professional that you hired? Because now I'm representing the buyer, not the seller. And, or the seller's agent who's loyal to you may be questionable or compromised. And so that's how I get around the, why don't I just work with the seller's agent to buy the house? Does that help? Everybody good with that? Okay. So how are you going to handle this when you go to your open house? And again, I'm going to tell you, take a look at that presentation. I thought I did a pretty decent job. That one's only 2 hours long, but there's some sections in there that just knock you out. I mean, they're just, here are the forms I'm going to have. I'm going to figure right away that I'm going to get a buyer representation agreement with people. But that's just the way it is. So 3 things to remember. One of them is do the forms library. So when you're in Zip Forms, I think Quan asked this question earlier, do the forms library. So always use the current forms in every transaction that you do. Okay. Do templates. So I teach templates. I teach how to create templates in Zip Forms. I offer my templates to people that ask for them. And again, it's job security for me because they're going to change them again. We just changed them, right? In June, we're going to change them again in December. So, so be aware that those templates are going to change every 6 months. But if you're using templates, then CAR will update your your forms library, and they will also update your template. They will not add forms to it. Again, I've been teaching this for almost 30 years. But do templates, folks. And then remember, do not copy transactions. And I had this happen. A broker came to me and said, "Can you review this file?" And I looked at it, I go, we haven't used the DA form in probably 2012. We got rid of that and replaced it with the PRDS form, right? So the DA was the disclosure and consent for representation more than one buyer or seller. And I said, "Where did you get this? It's not even available anymore." They said, "Well, I keep copying transactions." I said, "I get that, but you don't have the protection, the user protection agreement, do you?" So do not copy transactions without also applying your template. So I get it. You write an offer for a client June the 1st, and that deal doesn't come together. And then on July the 1st, we've updated the forms a week ago. You write another offer copying that transaction, and then you want to apply your template to that. So again, if you want a copy of my template, email me, send me an email. I'm more than happy to send you a copy of my template. And again, I'm going to change it again in December, so it's okay, right? But once you create a template, it's probably going to be good for a while. All right. Okay. Everybody understand that? I want to make sure you're clear. So let's talk about the form itself. And now we're going to go into a deep dive. All right. So here we go. I'm going to, what time is it? 11:17. What are we, almost halfway? You want to take a break? Elsie, I'm thinking about a break. Everybody want to take a 10-minute break, and I'm going to go into this form, and we're going to kill this form, okay? Question. Can you post your email? Yes, Kevin at SanDiegoRealtor.com. I'm sorry. Kevin at Burke Real Estate Consultants with an S.com. Down here on the bottom, you can see Burke Real Estate Consultants, but it's Kevin at BurkeRealEstateConsultants.com. I could go back. I will post it at the end, very clearly. I will post it at the end. I want you to be able to get a hold of me. I really do. And again, I don't charge for this. I just I don't charge you for this, but I want to make sure that you're all okay. Listen, I really feel like I'm not the only one who does this, but I want to improve the professionalism of our industry. And if I can help you, and you are one more shining star in real estate, then that means that you're going to make it a better world for the rest of us that want to do things the right way. That's all. We always hear about the bad actors and stuff like that, but we want to make sure that we're all doing what we can to make ourselves better and get better and better at what we're doing. So thank you, Amherst. That's a good question. Thank you. And again, if I knew how, here, can I type in my answer? There, let's see. Does that work? Send. And whoops, I may have only gone to Amherst. Okay. And I don't know how else to put it in here, but anyway, that's the deal. Okay, let's take a break for a couple minutes. I will be back probably a little short of 10 minutes, but we'll come back and we're going to pick this up where we left off, which is the very first part of this document. Okay, everybody good? Okay, 10 minutes. Be right back. I'm going to, if I stop share. Oh, there you go, all that. Look at that. Get me again. Thanks, Kevin. Whoa, here's a whole bunch of webinar chat stuff I did not know we had. I wasn't alive. Christina, God love you. I wasn't alive back then. I know, right? It's okay. It's okay. I wasn't alive. Oh, yes, I remember the NCR papers. Yeah, Amherst. Yeah. What do you consider standard forms? I think I answered that one. I did not get these questions. These are in the chat. So people are putting things in the chat, but I'm only looking at the Q&A. So I want to join the mailing list. So Henry, send me an email. Okay. I'm going to put it in here. I'm going to put my email address in here. Can I send it to everybody? Yes, I can send it to everybody. So here, let me put it in here. It's Kevin at. Yeah, sometimes I get, questions that I'm going to refer you back to your broker, but for the most part, I could probably help you with a whole bunch of stuff. So, Robert, hi, Robert. Good to see you, buddy, or hypothetically see you. Heavy-handed, I don't know what that references, but okay. Deborah, right for the builders. Heavy-handed 100%. Yeah, oh yeah. I think you're talking about the contract of adhesion, we call it, which is the contract that the developer hands you, right? And so what are some non-realtor licensees in California? Can they buy and sell real estate with non-realtor licensees? Sure, they can. I probably wouldn't. But Christine, that's a good question. So why would I want to work with somebody who did not subscribe to a written code of ethics? I mean, think about that, right? So that would ask the buyer that. So Amber says, my dad always told me buyers don't care what you know until they know how much you care. That is absolutely the truth. Remember what I said earlier about writing things down? You want them to at least think you care. Now, when I first got started, I've got a fairly photographic memory. So, I would ask them questions. I'd have it in my head. I still have the answers in my head 30, 40 years later. But I would write it all down. Why? And then I would leave the room and I'd throw it in the trash because, I didn't really need it because I had it in my head, but I was doing that for the effect. Okay, so I don't want to appear, disingenuous, but at the same time, I really didn't need it. Now today, I write things down and I keep it because, for a lot of other, legal liability reasons, things like that. So, Elsie, thank you. I'm blowing my break. Okay, I'm gonna go ahead and take a break. So, what do I do? Go off video? Um, no, I'm not sure what I'm doing. Okay, here we go. Welcome back, everybody. Thank you. I know I said 10 minutes and I got in here chatting just a little bit. And thank you all for your emails. I got a whole bunch of emails from people. Thank you so, and I know some of your brokers and some of them are really amazing people. So listen to everything they say. Yeah, I can't tell you enough, but it's important. Learn something new every day. Don't think you don't want to think you know everything because you can't. I don't know everything, and some people think I do, but you can't know everything. But I'm open to learning new things, and so same thing in our business is that you want to be available for the opportunity. When the opportunity presents itself to help somebody, I always say we help the homeless. But when the opportunity presents themselves to do that, then you want to help them where you can, right? And so again, not going outside of your field of expertise. So thank you, and thank you for your great comments. I really do appreciate it. And just as a side note, at the end of our presentation today, Okar is going to send you a feedback form, and you would help me out if you would complete the form. Okay, I just ask you for that. Complete the form. Remember that if you enjoyed the presentation, my name is Kevin Burke. If you didn't enjoy the presentation, my name is Mike Ferry. So yes, I always like to say that. And I know Mike, but I always say that. So anyway, God love him. Anyway, okay, so here we are. We're back. Everybody good? And again, I apologize. I didn't realize that we had people putting things in the chat. So I will try to make it a point to look at that. The Q&A field pops up a button that says that somebody's there, but it causes me to switch back and forth every now and again. So it's okay. We're all good. You put it wherever you want to put it. I will find you. I will answer your question. I want to help. So let's take a look at our document. And this is really important. So I've broken this down section by section, and we're going to cover quite a bit of this for the balance of today. So the buyer representation and broker compensation agreement. We've already talked about it being a two-part form, but it's really a two-intention form, right? It does two things. It creates a relationship between us and the buyer, and it also goes into the compensation. Okay, so, and then notice underneath the title, it says non-exclusive, unless exclusive is checked and initialed. And I think right there, I'm starting to think, oh my God, my head hurts, right? Well, non-exclusive means that you can do that. Check with your broker, find out your broker's policy. And if one works better for your broker than the other, learn what it is that makes that work. So ask your broker, what is your preference? Which do you want us to do? And then how do I get the people to agree to that? So I'm just going to give you definitional stuff. I'm not going to weight anything one way or another. I'm not a good politician. So non-exclusive means they can play with other people, right? And we're gonna see in the agreement itself that it's going to define what the two of them do, and you make that decision based on your input from your broker. Everybody okay with that? Question. What DU that listing agents? What's DU that listing agents write on CRMs to submit with offers? Okay. Roseanne is asking a good question. So when you're in the MLS and somebody puts in there, the seller's agent puts in their DU, says that I think that's direct underwriting, right? From the lender side of things. So in other words, do you have DU approval? I think that's that question, really not relevant to what we're doing in here, but I found my experience has been that sometimes agents will put things in contracts. that somebody else did to them before, and they thought it sounded really cool, like buyer to verify all before. I love that one. Buyer to verify all, including square footage. They write these things in the MLS, and they have to put it in the confidential remarks, which of course the buyer never sees, right? And so, and you're not allowed to give the buyer the confidential remarks. So, it's just kind of funny to me that you think that's a defense. I had a case probably about 25 years ago where the judge says, "What does that mean?" And I said, "I don't know. It's a lot like, the little red fire truck went through the stop sign, because it has no bearing legally to protect you." But so you'll hear all kinds of crazy little things. Again, check with your broker. Maybe that's their policy. I don't know. But good question. Thank you very much for that. Okay. All right. So again, very, very important. All right. It says unless exclusive is checked and initialed, and that initial is going to come in on paragraph number 15 later. But in the meantime, this is CAR form BRBC. This is revised when? June. Make sure you're using the current form. It's very important, right? Because if you're not, you don't have the user protection agreement from CAR. Right? And so you want to make sure you're using the current form. So make sure, just like when I take a listing, I make sure it is the current listing date. And sometimes it'll say, 12/24 because it hasn't been revised since then. But, if you want to come, hopefully I'll be able to talk OCAR to let me do the new forms releases, and I'll do webinars on that when the new forms are coming out. And then you'll see which ones are changing, which ones are new, and stuff like that. But in the meantime, double check this heading and make sure that it is the BRBC, okay? Because there's only one buyer representation agreement now, and then make sure it's the current date. Everybody okay? Questions on any of that? Chat? Nothing yet. Okay, good. All right. Okay, next thing, date prepared. And if you've got your purchase agreement with you, it'll help you a little bit. I'm just hoping you can see this, but date prepared. Remember, date prepared is the date you create this document, not the date of the agreement. The date of the agreement is when everybody signs it. Is that good? So this is the date that you put it together. So you're putting it together tonight, and you're going to have them sign it tomorrow. You never post date or predate, right? Very bad. Don't post date or predate. And so you'll put in today's date, and if they don't sign it till tomorrow, it's okay. You don't have to change it, right? Because it doesn't change anything. Okay, we're going to talk about the contract date versus the date prepared. So in the legal field, we call the recitals. This is the linking part of the document to all the other documents. So that's why we call them the recitals. However, the meat of it's going to come in a second. But the date prepared is the date you created. We're always going to reference this date, right? And not the date. Sometimes not the date of the contract, the agreement itself. Okay, good. Everybody good so far? So far, yeah. Okay, good. All right. Right to represent. So now, remember what I said before? This on the listing agreement between the seller and the seller's agent, it says hereby grants and employs. So we have employing language. That is an employment agreement. This is also an employment agreement. I've asked CAR to change the CAR to change this to hereby grants and employs, much like the listing agreement with the seller is, but so far, they haven't had a chance to do that. Sometimes, like that paragraph number 11M of the purchase agreement where it had the solar system being conveyed, right? And so I just argued with them for years, actually over a year and a half, because it said the solar system, and I'm thinking, okay, so now we're selling, interplanetary motion, we're selling Mercury and Venus and Mars and stuff like that. Well, what they meant to say is solar power systems. And so it just kind of finally got the right person, I'm not sure who it was that helped me change it, but it's like, please stop calling it that, right? Or stop calling it the termite report. There's no such thing, right? There's no termite reports. They are wood destroying organism reports or pest control reports, right? And when you go up to the state contractors board to look up if there've been any, you're not going to see a reference to a termite report. You'll see a reference to the wood destroying organism, the WDO. Okay. All right. Okay. So right to represent. So in the first line here goes the buyer's name. Now you always want to ask your buyer. This is critically, hopefully you're writing this down, folks, because I'm going to hit you with a lot of stuff. So the buyer, how do you want your name to appear on title? You never want to say, how do you want to take title? Because you're not giving them legal and tax advice, but that's what that question says. So you don't want to say, how do you want to take title? You say, how do you want your name to appear on title? Okay. Why? Because you want to create an enforceable agreement between yourself and your broker and the buyer. All right. So how do I want my name to appear? Well, if they're telling you the name is Bob, you know it's not Bob. You know it's probably Robert, right? So what I always do is I say, well, what does it say on your driver's license? Or the law enforcement, we called it the DL. What does it say on your DL? So your DL, you pull out your DL, and there's what your name is on your DL. That's what name goes in here. Because at some point, you're going to have to prove that you are that person. And the lender later on is going to want to know, what is your name? How does it appear? When you get your pre-approval letter, it's got your name as it appears on your documentation that you were going to sign for. Much like later on when we start signing for non-natural persons, we'll see that we need to be very careful about what we call ourselves. Is everybody okay with that? Let me see. There should be some questions on that. Nothing there. Okay, good. All right. What the heck? Ask questions. If you don't ask questions, I'm gonna start accelerating. So how do you want your name to appear on title? Buyer's name. So we only have two kinds of buyers, right? We have the natural person and we have the non-natural person. And so the natural person are those people who bleed when we prick them, and the non-natural person is everybody else. Okay. And in fact, I wanted to pull something up and show you this. Let me see if I can get this to work here. Buyer. Well, this is the buyer representation agreement. This is the original document. This is, and by the way, this is for the buyer, but we also have one for the tenant. So if you're representing tenants, then we have a separate document for that. Just be aware of that. Okay. And then this document is what I wanted to show you. So this is what I wrote. This is in front of the Department of Real Estate right now. And you've arrived when the Department of Real Estate calls you up and says, we can't wait to read your document. Okay, so this is the guide to buyer representation agreements that I wrote for the California Department of Real Estate, and this is available to you. OCAR is going to make this available to you in your stuff. So a lot of the things that were, and it's 18 pages. I don't know, are you going to read that? But I'm giving you the Cliff Notes version, so to speak, of all that right now. So be aware that's going to be available to you here shortly. Okay, everybody okay with that? So that's why when I say, some of these things that I'm telling you, I'm going to reinforce it that's in that document. All right. So right to represent buyer, natural person, non-natural person. Natural person, anybody that bleeds when you prick them. A non-natural person is everybody else. And so if they are a non-natural person, if the non-natural person is buying the property, assuming the non-natural person can get a loan, right? A lot of times people want to buy it in their trust, or they want to buy it in their corporation. Well, are those people pre-approved for the loan, or are they paying cash, things like that? So those are questions you got to ask. All right. Okay. Now, Grants, the broker, that's going to be your broker's name. Okay. So if you're with the gold people, then put in the gold people. If you're with the balloon people, put in the balloon people. Whoever you're with, that's the name of the company, not your name, but the name of the company. So Grants, that DBA that's being done. And again, I don't want to sound like a law class, but sometimes you gotta know some of these things. Okay, so what is the broker's name? Oh, you can see that. So what is the broker's name? If you don't know who your broker is, check with your broker and check with the Department of Real Estate. Call me, I'll help you find out who your broker is. Okay, I do get those calls where people say, I don't know where my broker is. I haven't been able to get a hold of him in months. It's like, okay, well, we have other things we're going to talk about. The non-exclusive. So the default language in this agreement is non-exclusive, which means you don't owe me anything. You go out and do stuff on your own, whatever. We're going to define what that means here in a couple minutes, but unless we check exclusive. And that's going to be paragraph 2A, which is going to come up in a second. And then we're going to have to check it again in 15, as you can see right here, and initial in paragraph 15 to represent the buyer in acquiring real property or a mobile home. Remember, we don't sell personal property. I see this happen in a lot of real estate transactions, and unfortunately in litigation, where the agents were involved in selling, works of art in the property and cars in the property. And it's like, you don't have a license to do that. Right? You have a license to do real property, land or anything affixed to the land. But I see people do this, and I see them getting in trouble. I had a lawsuit that was $3 million worth of personal property items. Right? I mean, it was, and the sale of the home was a lot more than that, and so then it ended up in litigation over the personal property items. So you want to be careful about those personal property things. So in acquiring real property or a manufactured home, okay? Doesn't say mobile home. A mobile home is something that's got wheels on it. Manufactured housing, we have a license to do that. If it's a mobile home, then it's probably going to require a dealer's license, a separate dealer, a dealer's license for mobile homes, okay? So again, check with your broker because every situation is going to be different. Usually they take the wheels off, they attach it to the ground, they got utilities piped up to it, they put a skirt around it, and it's got a HUD stamp usually. So anyway, for the representation period, so this is for the period. Remember we talked about date prepared a minute ago, but now we're going to talk about when are we going to have this agreement come together, and we're gonna hit that here in just a second. So terms of the representation, these are contractual, right? And the paragraphs, we're going to see the columns are going to refer to further explanation later, and I'm going to bring in the DRE again here in a second. This form is 5 pages. Buyer is advised to read all 5 pages. I have lobbied with CAR to change that to buyer and real estate agent are advised to read all 5 pages because, as I said earlier in our talk today, most times they just never read it. And it's like, it has to be written in plain English, but I'll have people quoting me things from the agreement, and they'll be quoting me something that I was just talking to Linda about this, quoting me something that was in the agreement 10 years ago. And it's like, I guess you haven't read it recently, right? Well, that's why we do these things, and that's why, again, OCAR is at the head of the pack as far as education is concerned, because we want you to be current, right? And so we're advised to read the 5 pages, and this is where the Department of Real Estate is going to come in. Their major concern, especially with the RPA, by the way, was that we would stop reading it after paragraph number 3, and paragraph number 3 was all the stuff you fill in, right? There wasn't anything to do after 3. So, other than if you were going to do liquidated damages or arbitration, there wasn't anything to do. And so as real estate agents, were we explaining the forms properly? So, and that was their biggest fear. And they said this to me when I was teaching their special investigators. So paragraph number, this is the beginning of the heading of the next part. So we're going to have the paragraph number. That's the one that it references. We're going to have the title or the contract term, and then we're going to have the terms and conditions. Okay. And so representation, we're going to hit on the representation now. So what is my representation period? And so I'm going to tell you something that I see this very frequently, and I call it DRE audit, but it's an audit before the department shows up. You want me there before the department shows up, right? Because when they show up, it's not usually an educational thing, right? They say it is, but it really isn't. But you want to look at this. What's this period of time going to be? So a lot of times agents won't fill this in. I had a case just recently where the agent said, well, we didn't fill it in because we wanted to be able to change it whenever we felt like it. Well, when you put things in the MLS and when you do contractual things, the assumption is you've completed the forms properly. And if you don't put in the beginning and the ending date, then you haven't completed the form properly. So let's talk about this. This is going to be paragraph 2A1 right here. Okay, so beginning on a certain date. So a date certain. The law likes a date certain. Doesn't say 30 days. 45 days. I hate that in the RPA. It says a date certain, beginning on what date and ending on and at midnight, ending at midnight on what other date. So a beginning and ending. Now, how long should that be? I don't know. I just know that it can't be. I'm going to see in a second. It can't be more than 3 months, right? If it's a natural person, okay, can't be more than 3 months. All right. So how long? I don't know. If I'm holding an open house, for example, and somebody walks in on a Sunday, I can make it just for Sunday, right? Can I make it for Sunday and Monday? They're going back to Connecticut on Tuesday. Can I make it for a short period of time? Can I make it for a long, again, limited to 3 months? So it could be just for a day. It could just be for the open house. Is everybody okay with that? Again, check with your broker, but that's why we have a beginning and ending date. There's nothing in there that says it's got to be 6 months, it's got to be a year, whatever. There's nothing going to say that, but it has to have an entry in there, and it'll be a drop down calendar on each of these, or upon completion of the transaction, right? Because if you complete a transaction prior to this expiring, then you no longer have an agency relationship with the client. I just had this conversation with a lawyer the other day. You no longer have a contractual relationship, no longer have an agency relationship, and now any advice you give these people after that is going to be legal advice. And so you want to avoid doing that, all right? And again, if I'm speaking too fast, slow me down, say something. You put it in the chat, put it in the Q&A, and I'm happy to answer your question, okay? All right, okay, so not to exceed 3 months. All right. So that's just, we did that on purpose. I always taught never to go over 3 months because, listen, they haven't bought a house in 3 months, then, yeah, I'm doing something wrong, or I'm not getting the right message, or they're not real. And I want to be able to get rid of them. Right. I mean, I've had, I had a business partner back for 15 years actually who had one client. It must have showed him 40, 45 homes, wrote offers on 20 of them. And I read all the offers in the office in the company, and I was getting tired of writing offers for these people. And every time I wrote the offer, the husband would show back up in town and he'd kill the deal. And so it's like, they're not real. So, do you want to have an agreement with somebody that's not going to perform? And so that's why I said you may not want 3 months. Okay. So Civil Code 1670 says that the representation period can be longer if it's an entity, a corporation, LLC, partnership, by Civil Code. Otherwise, the representation period exceeds 3 months and the buyer is not an entity, then this agreement is void. And so let me explain void to you. We have void, voidable, we have valid, we have invalid. Those are the four terms. Not that we don't want to do a law class here, but void means it was never created in the first place. Right? Amorous, you and I, we agree, we write a contract up between the two of us that we're going to rob a bank on Monday morning. At 9 o'clock, you and I write a contract. We're going to go into the bank. We're going to rob the bank, and we both sign it. We notarize it. We do whatever, and then I don't show up, and so you sue me because I breached the contract. I didn't show up, to rob a bank, right? Now, obviously, this is a fictional situation, but I want to get your attention with it. So, obviously, I didn't show up. So, do you have a breach of contract with me? And the answer is no. The contracts to break the law are void as a matter of law. They're void. You're not allowed to create a contract that breaks the law. You can't do that. And so that contract that we did that created, we're going to go rob a bank on Monday morning is not going to be enforceable at law. It is void. So that means it is void at the onset. It never existed in the first place. Versus voidable usually means one person can void it depending on the circumstances of that. Depending on the circumstances of that agreement. Okay, but void means you never created it. It doesn't exist. Okay, all right. So void, very powerful. All right. I've asked CAR to do a presentation on the difference between cancellation of contract and rescission of contract, because those are very powerful things. And otherwise, I'm just going to go ahead and do it, and then I'll put it out there, and then people can, I don't know, get over it. I try not to get in front of CAR if I can avoid it, but all right. So A2, so we're on 2A2. Type of representation. There's 4B, which means it's going to go deep into this conversation down further on paragraph 4B. Okay, so type of representation, non-exclusive, as I said earlier, by default. So if you don't check the box here, then that means they can go do whatever, right? And you're not, and we're going to talk about what that means, right? I mean, we're going to talk about introducing them to property and what we call broker involved properties and things like that. Or you can check the box that says exclusive. And again, I'm going to ask you to check with your broker and see what your broker wants you to do. In our company, we check exclusive because, we're just not, we want agreements that if I'm going to go show people property, I don't want to be wasting my time. Now, remember that this also puts some responsibility back to you, that you've got to tell them, what the gotchas are going to be. So, for example, thou shalt not buy the Porsche. We have the 10 commandments of buying a property. Thou shalt not buy the Porsche during the home search process. Thou shalt not buy the washer dryer on revolving credit, and then you'll fry your credit rating, right? Because it lowers your FICO scores and things like that. So you got to have these conversations with people. That's only fair. And if you wonder what that looks like, let me know. I'm happy to help you with it. But again, obviously they can go make major purchases and mess the whole thing up. Okay, so if we check the box, it is exclusive, which means just you and me, right? Valid if only if checked and initialed in paragraph 15. So we're going to remind the agent, but we're also reminding the buyer that this is not going to be exclusive unless we also do paragraph number 15 later, okay? Property to be acquired, and let's talk about that. So broker, including any associate licensee working through the broker on behalf of the buyer, provides services for the types of properties and in the location specified below. And so here's my list. I've got property types. And again, remember, these are questions you want to ask your buyer. I'm already creating my buyer consultation, right? I'm writing all this down. So, for example, how much do you want to spend? How much, what areas are you looking in? What zip codes? Are you looking for a townhouse, a condo, a single family home? Are you looking for land? These are all questions that this form is meant to trigger, because you got to ask the question, and it's telling you what questions to ask. Is everybody all right with that? That's kind of important, okay? So single family residential by default property type, okay? And single family residential can be, a townhouse, a condo. It's meant for single occupancy, right? Not a fiveplex or sixplex or something like that. Now we're getting into commercial, right? So they check the box which ones they want it to apply to. That's all. Single family by default, but they can do other things as well, okay? You'll find a lot of areas now that are, for example, downtown San Diego, a lot of tenants in common. We call them TICs at law. And so, there may be some things that specific to this agreement. I think most people are just going to leave this at single family residential. Is that good? Okay. All right. Questions on any of that? Popping up my little thing here, and no questions. Everybody still there? Okay. All right. B2. So location, you need to fill this in, and here's why. The courts have held that if your agreement is overbroad, then it's not going to be enforceable. The more limited you have in your agreement. So if I put 1, 2, 3, 4 Main Street, that's how creative I am. Put 1, 2, 3, 4 Main Street, and they buy 1, 2, 3, 4 Main Street, I'm their guy, and I'm going to be the one that gets paid in the transaction. But if I put California, oh, my license says California, I guess California, I put California in there, then it's probably not going to be enforceable because it's overbroad. It's way too, you need to limit it. You need to narrow it down a little bit. Everybody okay with that? And again, I know you're writing these things down, but you can put in the county, you can put in the city. I always put in like 5 zip codes. If they were looking at Del Mar, then I want to cover myself for La Jolla. I want to cover myself for, Rancho Santa Fe, Carmel Valley. I'd want to cover myself for that. But I think 5 was probably most. Now, if they come back to you later on and they say, I'm not finding anything I want in these areas, I'd like to expand my search to Escondido and Poway, you can always amend your agreement. All right. But that's easy enough to do. But start off with something that's a little bit limited, okay? And they can always change their mind. They can always add to it. They can always subtract that. An interesting conversation with the real estate agent the other day, because CAR has finally come out with an amendment form versus an addendum form. And addendums are when we add to a contract, and an amendment is when we change a contract. And so they just never have that in there. They finally come out with it. I'm very excited about that. But in the meantime, here I'm going to start off with San Diego County, Orange County, or Riverside County, whatever. And I want to limit it as much as I can, because the more I limit it, the more enforceable it's going to be. Okay. All right. And I was the manager of an office in Orange County, off of San Clemente, in San Clemente, and I remember I was having a conversation with one of my agents who the buyer had gone and bought a property without him during the representation period. And so I went through a series of questions that I asked the agent. Did you have an agency disclosure? Yes. Contract signed by all parties? Absolutely. Blah, 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 blah. And then the attorney for our company walked by my front window and my office, in the hallway. And I went out and handed him my phone. I said, here, take care of this. We got a check for $36,000 from the buyer who had gone around us to buy the property. So these things are enforceable. So just be aware of that. But again, they were very explicit about what they put in there. Okay, everybody good? People ask me sometimes, have you ever seen one of these be enforced? All the time. It's a contract. It's going to be up to your broker, because it's your broker's contract, right? Okay. All right. So that's 2. So let's take a look at additional description. So what if there's more to what they're looking for? They very specifically want a house with a koi pond, or they want a property with a heliport in the backyard. There are those properties. I've shown those properties before. I mean, there are a smattering of them out there, and less of them actually listed for sale. But they might have some kind of an additional description that they're going to want about that to again create the terms of this agreement. And again, the more thorough you are with this agreement, the more likely it's going to be enforced. Okay, everybody okay with that? I'm just checking to make sure I'm not missing. I changed a whole bunch of stuff. Hold on a second. So that's my additional description. Okay. All right. So now we're going to talk about 2C, which is additional buyer preferences and priorities. And so there may be more that they want to look at. And so I'm gonna pull that form up, but I want to remind you this is not a forms class for the ancillary forms. Again, that's a separate class that I teach. I teach a whole class on disclosures, how to fill out your Avid, what is going to get you in trouble, what's not going to get you in trouble. And again, I just happen to be one of those guys that's got my feet in both worlds, where, I'm involved in a lot of litigation. I get asked by attorneys all the time for my help on things. And so, I want you to be okay. But this is going to be, let's take a look at this additional buyer preferences form. So let me see here. I'm going to close this window. In fact, I'm going to close the tenant window because you're all aware, I just showed you this a second ago, that we do have a tenant representation form. And then here's my buyer's identification of preferences and priorities. Okay, can you see that issue? Okay, so, it says number one, because we may have a second one or a third one. We haven't edited it since July of last year, right? But it talks about this question. Okay, hold on. Robert, to confirm, if your buyer only wants to do the BRDC to a specific address, absolutely. We would check the cities and write in the actual address. No, you would just write in the address. Additional description, it might be 1234 Main Street. Good question, Robert. If your buyer says, I only want you to represent me on this one property, you can do that. Understand that if they buy the house next door, you may not be, covered by your agreement. This agreement says that you agree to allow me to represent you, but you also agree to compensate me. So, but sometimes the buyers, got other things. We'll talk about that in just a minute too. So, Robert, hopefully I answered your question. But if your buyer only wants to do the BRDC to a specific address, absolutely do it to a specific address. There are reasons why you would do that. I can think of a couple of them. Okay. All right. Good. All right. Let me see here. Okay. Making sure I don't have any other questions. But if you have a question, please put it in there. I've got a whole, how much time do I have left? I got, what? I got an hour left, right? Oh gosh, we're never going to make it. Okay. All right. Well, that's a lot of stuff, and again, like I said, at the end of this talk today, I don't pass away that I'm aware of, but, I'm here to help you. So if I can, I'm happy to do that. I'm not going to get in front of your broker. So that's just the way it is. So parties and property here, and then I've got identity. So again, these are my recitals. Okay. Identification of the buyer's preferences. And then here's my whole little thing. How much do you want to spend? This is half of my interview, right, with the buyer. All right, what are you going to use it for? What kind of properties? What features do you want in the property? If your buyer says, I've got a family of 12 and but I'm looking for a 1-bedroom, I'm thinking, well, maybe you might want to consider it. Could be a really big 1-bedroom, I guess, right? But these are some of the questions you're going to ask people. It has to have a pool. It has to have gas appliances. I don't want septic. I want it to be on city sewer, things like that. Where do you want it? Other things. So this is actually a pretty good form. I never see this form used, but I think it makes a great part of your buyer questionnaire. Okay, absolutely. All right, everybody good? Let's go back over to the agreement. And so good. So see the form. If you check the form, if you check that box, it brings the form into your buyer representation template, and then you're good to go. Paragraph number D, properties excluded from representation. Now, obviously, I've read ahead. I know what the document says, but here's what that's going to be talking about. There are going to be certain properties that they don't want. Like I went into this property and I saw it, and I told them that if I didn't find another property, I was going to go buy this one. And so the buyer would want to put those properties that are excluded into this paragraph number D. So whichever ones those are, or it could be that they have an agreement with another brokerage, as Robert says. Robert has an agreement with the buyer to buy that one property, but because their agreement is only for that one property, they could have an agreement with other people to write offers and receive compensation on other properties, and so those properties would be listed in here, or you could have an attached list. Is everybody okay with that? Pretty important concept. Remember that as much, I want to get, I had to fire somebody actually a long years ago, because they said, no, I want to take advantage of the buyer. We don't work like that. I'm sorry. I don't know. It doesn't work in my brain, but, we're not here to take advantage of people. We're here to protect the public. I remember having a conversation with the commissioner back when, what was his name? The one after Wayne Bell. I was chair of Realtor Risk Management and Consumer Protection for the state of California. And so two things, right? Realtor Risk Management and Consumer Protection. And then I went from that meeting over to a meeting with the commissioner, and I said, we're in the same business, right? We're both involved in consumer protection. We want to help the consumer. We want to protect the consumer. And if we're throwing the consumer under the bus, then it's just going to be counter to everything we're trying to do. Okay. So definitely, behave yourself out there. So definitely we want to protect the buyer from committing themselves to work with us. And then you get legal issues, like if it was after written document, then the first one would apply. We don't want to get into that. We don't want to get into a legal battle. The only ones that win the legal battle are going to be the lawyers. And so, we don't want to do that. Okay. All right. So E, now my favorite subject. Okay. And by the way, this is my dream webinar that we're on today. It is something I'm very passionate about. And as you can probably tell, broker compensation. And so these are the words required by the Department of Real Estate. The amount or rate. So amount would be a dollar figure. The rate would be a percentage of real estate commissions. Is not fixed by law. We have to put this in all of our employment agreements. Okay. Listing agreement, prior representation. They are set by each broker individually. So again, not you, but the broker. And we have some brokers on here, but your broker sets by virtue of usually your ICA, your independent contractor agreement, how much they want you to charge. Okay. Whatever that figure is. So we have to tell the public that. The broker establishes that, and it may be negotiable between the buyer and the broker. A lot of people think that the agent sets that commission. No, the agent has a minimum that they have to hit for the purposes of their brokerage. But if they do something short of that, then they just have to explain it to their broker, okay? Because their broker approves or disapproves of this, and that we're going to talk about management approval here shortly, where the broker can actually say, "I'm not going to do this deal. This deal's dead. We're not doing this representation agreement." So may be negotiable, and I always tell the client, I always say, "Oh, it says may be negotiable," and then they say, "Well, so will you reduce it?" I said, "No, it may be negotiable up." Not down, whatever that is. I always told them, well, maybe means I can charge you more. I might decide I'm going to charge you more. I mean, whatever that is, right? But and then they always laugh, and it's kind of a nervous laugh, right? They're not sure, if I'm picking on them or what I'm doing, but it could very well be that there's more to the story. So anyway, see attached broker compensation advisory. So let's take a look at that as I changed my screen. So we're going to go over here again, and I'm going to start deleting. So this one is the identification properties. Let's see, broker financial. No, I already do that one. No, I didn't do that one yet. Where's my? Here we go. Broker compensation advisor. I tried to put them in. I tried to order them, but apparently I didn't do it right. Broker compensation advisory. This is fairly new. This form came out after the Sitzer Burnett decision. I love this form, right? And it's really nothing for you to do on this except read it. And so again, folks, I'm going to ask you, I'm going to beg you, please, at some point, read these documents. You'll have them all. They're all current. They're all going to be given to you by the Orange County Association of Realtors. You need to look through them. All right. I mean, memorize them. No. Write a book on it. No. I mean, but look through them, because they're going to give you guidance on what you can say and what you can't say. And in my conversations with the previous commissioner, it's like, stay in your lane. And so if you and don't be saying things that are inconsistent with the agreement. Like, well, square footage is, 37,000 square feet. And it's like, well, but it says everything we've got says that, you don't know how to measure square feet. You don't know what square feet is. And so when you make that representation, you create a problem for yourself and for your broker. Remember, we always say we love our broker. We want to make sure nothing happens to our broker, because if something happens to our broker, it happens to us too. Okay, all right. So broker compensation advisory, when sellers list their property, this is what it looks like. Listing agreement is fully negotiable. Optional additional compensation. Thank you. Who was it? Quandis? No, it was Jim. Jim, did you bring that up? I think Jim brought that up earlier. Was that optional? Where was it? I'm pretty sure it was Jim. Yes, commission versus compensation. Very good. So we stopped calling everything commission. We changed all the names on everything. Now it's all compensation. Okay. So broker may represent both buyer and seller. That's dual agency. That's that PRBS form. That's the form that we in California get them to sign in advance of the transaction that authorizes us to be dual agents in the event that we become dual agents. Not all states allow dual agency. Some states have designated agency, things like that. Again, I do a different trial in Virginia than it's going to be in California because in Virginia they do designated agency. I have a case right now there. So broker agreement with the buyers, and again, you can read all this stuff on your own. Requirement for written agreements. This explains all the stuff. So if you read this, it'll help you to explain, to get the salient points down there, but you have to have read it. And that's what the Department of Real Estate is kind of looking for to make sure that you've done that. So the buyer pays the compensation pursuant to a buyer representation agreement. It explains that. Seller pays the compensation. The buyer negotiates for the seller to compensate the buyer's broker. Buyer negotiates an agreement directly with the seller. So when the buyer writes their offer, they say, please pay, I owe my broker X. Please pay that. And then the seller can come back and say, I'm not going to pay that, but I'll pay this instead, maybe more, maybe less. I just closed one in Malibu that was 5%. And it was before this agreement. So, but what did I have to do? I had to disclose to my buyer that the seller's agent was paying 5%. In that case, it was the old, before Sitzer Burnett. And so why did I have to tell them? Because otherwise it's called secret profit. We want to make sure we don't receive any money that the buyer's not aware of, especially when we have a buyer representation. Okay. All right. So this goes through all this kind of stuff. It's not the subject of today's class. So I'm going to pop that one out of there. And then let's see what else. Okay. So I'm going to go back to my PowerPoint. Okay, so amount of compensation. This is where you're going to put in either a rate, percentage of the acquisition price, and if anything else. Now, people used to put in TC fees and stuff like that. I remember I was in a meeting with the deputy commissioner, the district manager, who said, we think that's a junk fee. Charging the buyer, charging the seller for your TC is a junk fee. That's work that you're being paid to do by virtue of your agreement with the client, right? And so, you know what? I got to agree. But we were putting TC fees in our agreements. This all changed. This is October of 18. I remember sitting down in a meeting with her with a whole bunch of lawyers, and she made that comment. I went, oh boy, okay, we're changing our company policy on this because we don't want to run afoul of the Department of Real Estate. So so when we get that, we want to we want to make sure we're not charging junk fees. For showing several homes, Adrian, showing several homes, should we put all the addresses? Yeah, and we have a form for that too, where you can a list of broker involved properties. And the argument has always been, should I provide that list of broker involved properties before I show them? Should I do it after? I think you should do it before. But if you have an exclusive agreement, I don't think you need it as much as you do if you have a non-exclusive agreement. Okay. So good question. That's a good question. If the buyer's already signed a BRBC 3 months and is submitting offers with that agent, can another agent come in and have that buyer sign exclusive for a specific address? So let me see if I understand your question, Deborah. So if the buyer has already signed an agreement, is it exclusive? If it is exclusive, and then the buyer then signs another agreement with a buyer for a specific address, is that address outside of the zone of the original agreement with the first agent? So if the first agent, yes, okay, good. So other agents signed exclusive. Okay, so and again, Robert's question was like that too. Robert does one for a specific address for a buyer, and then another agent has an agreement. This is after Roberts, not before. After Roberts, then another agent signs an exclusive agreement with the buyer for an outside of that area where Robert's property is. Again, I said afterward in case, because we want that one that first came into place to control, and we don't want the buyer to be conscripted into, having to pay several commissions because the buyer may end up having to pay two commissions, and we can't do that. In the interest of equity and fairness, we can't do that. Both properties are in Orange County. Does the original buyer representation agreement say Orange County? And again, if this is the before scenario where you're doing, yes, OC. So the original agreement is with Orange County, and then the buyer signs another agreement with another agent for a specific property also in Orange County. That's going to be a problem. They have to explain, and we're going to see a paragraph on that where they're going to have to explain to that other agent that they already have an agreement to representation for Orange County, and that property is in Orange County, and so we don't want to get in front of that agreement. Okay, so can we put down Sangeetha? Good, welcome back, by the way. Can we put down a mix of cities and zip codes? Sure. Yeah, don't go crazy, or list a specific address and a couple of other cities. Sure. Right, but remember, and so I'm going to tie this question into Deborah's question, and that is whatever you put down there is going to be, you have to explain to the buyer that they can't go signing other agreements with other people. And again, there's a lot of moving parts here. Again, if it's exclusive versus non-exclusive, is the second agreement in an area where they were already obligated under a previous agreement. Those are things that we don't want the lawyers necessarily get involved in this. So we want to check with the broker first, check with your broker and say, here's what they've got. You can always ask the buyer, send me a copy of the previous agreement that you signed or whatever, and let me check with my broker. But in all fairness, we don't want to commit our buyer to paying two commissions, right? Because if under Deborah's scenario, they buy a property, they have an agreement for a specific address that's also within Orange County, they're going to owe that broker a commission and the broker that they signed an Orange County agreement with. Okay, so we don't want to take advantage of them. Okay, told buyer he is obligated to his present agent, or he may have to pay two agents. Exactly, Deborah nailed it. Good, excellent. And talk with your broker about it, because I don't know what your agreement says. So, but if the buyer is getting into a situation where we're going to have to pay compensation to multiple brokers, then you need to let them know that they're getting into that area. Okay. All right. I just saw a question. Quan. So you are saying we can no longer put TC fees to be paid by the buyer on the BRDC. So let me remind you what I just said. So I'm telling you that the district manager for the Department of Real Estate says we think those are junk fees. And I've dealt with the Department of Real Estate long enough that when they say we think, I'm like, I ain't gotten anywhere near that. But check with your broker. Whatever your broker's position is, you need to check with your broker and have your broker tell you how to handle that. Okay, I'm just telling you about a conversation I had in a meeting with a whole bunch of lawyers, and the district manager was there and made the comment, we think those are junk fees. And so she didn't say don't do it. I took that to mean I ain't doing that anymore. Listen, I don't want to run. I like these people. They're good. They're very good to me. The DRE is very good to me. I like the DRE, right? But I'm not going to put my head in the mouth of a lion if I don't have to. So good question, Quan. Second part of your question is, so where can we put that? I don't know. Because you're limited by how much you can. If your agreement says, for example, let me go back to the agreement. If your agreement says, I always pay my own, buyer was not aware of this, I always pay my own TCVs. Okay, so if your agreement says 3%, and now I lost my train of thought. Okay, so if you're agreeing, because I was reading somebody else's comment, but if your agreement says 3%, the DRE's statement was that you should be paying those TC fees. But if your broker has a different policy, follow what listen, you need to please, I said this from the beginning, you need to talk to your broker. Do what your broker tells you to do. And if your broker has a question, they can always call me. I'm more than happy to answer that question. Okay, good question though. But I don't know what you would put in there. I mean, it's kind of like, paragraph 3Q of the RPA, it says seller will pay for this, buyer will pay for that. I don't know what you put in there. I mean, everything else is all outlined as what's going to be put in there, but I'm just telling you that that was their statement in a meeting that I was in, again, back in October of 18, and I don't know, 7 years ago. I don't know if it's changed much since then. Or it can be a dollar figure, or there can be a broker created compensation schedule. I can tell you that in all of my years in real estate, I've never seen one. I've never seen a broker created compensation schedule. It's usually, excuse me, it's usually addressed in the ICA agreement between the agent and the broker, but I've never seen a broker create one that says maybe, up to 500,000, I charge 12%, up to a million, between 500 and a million, I charge 6%, up, from a million to a million five, I charge $10. I've never seen that. So it's there, but that's just in case there is one out there. Everybody good with that? Compensation, very important. I want you to get paid, whatever it is. I want you to get paid whatever that figure is. And again, after consulting with your broker. Quan, thank you. Great question. So I in our office we don't allow it, and I counsel a lot of brokers, and that's one of the things I tell them, don't do it. But again, please do what your broker tells you to do. It's very, very important. And I do, you can always call me. I'm always happy to help you if you have a question about something, but I'm the first one that's going to tell you, you know what, that's legal advice, or that's your broker's, venue, and I'm not going to get in front of your broker. Just not going to do that. So, okay, good. Okay, that being said, let's close that window. Okay, so everybody good? Anybody else have any questions about 2E1? Non-compensation? No? I didn't create enough anxiety? Okay, all right, that's fair. 2E2. Payments received by the broker from others, from the seller or others. So this is important. If the broker receives compensation from the seller or somebody else, so don't care, for the broker's representation of the buyer, the amount shall be credited against the buyer's obligation to pay the broker. What does that mean? Let's say and we're just going to throw a number out here. The buyer's buyer and the buyer's broker have signed an agreement that says 3%. Okay. And the seller comes back with a counteroffer, which, by the way, it's in a counteroffer now. It never used to be. The original, I showed you that one-page purchase agreement, and I hate to. Oh, I closed it already, so I'm not going to bring it up again. But at the bottom of the form, it had how much the seller's agent, or the listing agent, we called it then, and the selling agent were going to be paid. Well, it created all kinds of problems for agents. How do I do that without telling the buyer how much I'm getting? Well, we've really gone back. This is 1991 that we changed the rule that said now we're going to have the seller pay the buyer's agent's compensation. So that was, I don't know, what we did in 1991. We changed the rule. So now we're going back to that. So if the buyer has agreed to pay the buyer's agent 3%, let's just use that number, 3%, and the seller comes back and counters the buyer's request for 3% and says, I don't care what kind of an agreement you have with your buyer's agent, but I will compensate you something. I'll give you 2%, right? So that amount would get credited against the buyer's obligation to pay their broker. So what does that mean? That means that the seller's going to pay 2, which leaves a point outstanding that the buyer will be expected to pay the buyer's agent. Now they have contractually bound to do that, right? And so again, enforceability belongs to your broker. So you need to talk to your broker about that. What do we do? In most cases, I see most agents just caving on it and just going with a 2. But here's the point. You can't collect more than that. So whatever figure you put in there, if it's 3%, you are not allowed to collect more than that. But if the seller compensates you less than the buyer's obligation, so the seller contributes less than the buyer's obligation to pay the buyer's broker, then again, 2 things happen. One of them is the buyer owes you the difference, owes the brokerage the difference, or talk to your broker. I would recommend talking to your broker because, as I said just a second ago, enforceability belongs to your broker. Everybody good? Probably a little more complicated than people thought it was, right? Okay, all right, good. So broker shall not receive any amount in excess of the amount specified in 2E1. So in 2E1, which was this previous paragraph that says, we're going to get 3%. Again, we're just using that as a number, 3%. So if the seller's agent, the seller comes back and says, I'll give you 4%, you're not allowed to collect that. And it means from any source. All right. So, at the end of the day, when all the numbers are done, it has to be no more than the amount that was in paragraph 2E1. Everybody good with that? That's really important. Right. And I see, problems resulting from, we used to give away cars, crazy stuff that you just can't do that. I mean, it's just not going to work. So is everybody good with that paragraph? All right. Okay. 2E3. So continued right to payment. So this is the old what we call the safety clause or the protection clause. Again, it was on the state exam, right? How long is this agreement good for after expiration or after cancellation? And the answer is it shall be a certain number of calendar days after the representation period or any extension. Okay, so that's how long it's going to be good for. So I don't know, what do you put in there? 30, 60, 90, whatever. I probably wouldn't exceed 90 because your original agreement can't be for more than 90 because it said 3 months, right? Everybody good? So put in a figure. If you don't put in a figure, the court's position has been you didn't care about getting anything paid after the cancellation or after the expiration of the agreement. So you've got to put a time in there, or if you don't put one in there, then you have nothing, right? You get nothing if something happens afterwards. Is everybody okay with that? Pretty simple explanation of what that's going to look like. Okay, all right. F, let's talk about F. So cancellation rights and notice. So non-exclusive. Cancellation is effective upon receipt. Non-exclusive. Remember, you guys go play the field, do whatever you want to do. So you send me cancellation and I'm done right now. Again, I don't know, that doesn't work in my business model, but it may work in yours. And maybe, again, there's a lot of different business models out there, and I'm not going to get in front of any of that. Some of them are pretty good, right? But mine doesn't allow for that. We always do exclusive, but okay. Or it can be a certain number of days after receipt, so 10 days, 30 days, whatever. Exclusive cancellation is effective 30 days, okay, or some other figure not to exceed 30 after receipt. So the exclusive representation is going to be 30 days. You could make it 15. It just can't be 45. Does that make sense? Okay. All right. Everybody good with that? So, what do? We leave the default, but that's just how we do it. And again, check with your broker on that. Buyer financial personal information. So time to deliver this personal and financial information. So if you're going to accept that, okay, and remember, check with your broker if you want any personal or financial information from the buyer, because we've as a matter of policy, a lot of brokers don't want like social security numbers, account numbers on bank statements, things like that. They don't want it in the file, right? That's one more level of identity theft that they may have to protect themselves from. So let's take a look at that form really quick. Again, not to get into a forms class here, but that's this form right here: buyer financial and personal information. Again, if you're going to collect it, maybe your brokerage does loans. I'm sure they have another form that's a little more than this form, but that would be what you would do if you wanted to get that financial information. Everybody good? Okay, all right, going back to our document, moving right along. The buyer does not have sufficient funds to pay the broker. So they got to tell the broker up front, I don't have the money. And so, I'm agreeing to pay you 3%, but I don't have the 3%. Okay. So then when you write your offer to the seller, the buyer's going to have you, right, put in the amount of compensation, the 3%, whatever figure. I've had them recently where we had a 3% agreement with the buyer, and then the buyer on a particular property said, I only want to, ask for 2. And that's the buyer's decision. Of course, the buyer would then owe us the other point, but again, check with your broker as far as enforceability is, whether they're going to enforce that or not. But the buyer tells you up front whether or not they have the money to do the deal, and then you get to make the decision as to whether or not you want to work with them in the transaction. Does that make sense? Is everybody okay with that? It's a cognitive decision that you're going to make. Okay, where'd y'all go? 14. Okay, all right. Other terms. So you always have to have other terms, right? Because it could be something that you were doing a little bit differently. So that's where you would put in something that your broker would suggest. I'm always very careful. Counter offers and addenda are the ones where we write in stuff, are as close as you're going to get to giving legal advice to your client. So be careful what you write. I know when you write an offer, if for some strange reason, sellers agents, it's a knee jerk that they have to write a counter offer. Sometimes the counter offer might not be a good move, right? And so, like, for example, you get 5 multiple offers. You go into a multiple offer situation, 5 different buyers, you counter all 5 of them, they all disappear, right? You got to be careful. That's a judgment call. Some of us are like really arrogant, and so we're going to write a counter offer. We have a canned counter offer in our template that we have it prepared because of some of the things that we see there fairly commonly. done incorrectly in an offer, but that's what that's all about. So so be advised that a counter offer is not always a good idea. But that's again the language you write in that counter offer. I would recommend, and again, I have a whole. If you go to my YouTube, I have a whole thing on how to handle seller counter offers and seller multiple counter offers as a different process, and they're all up there on YouTube. Go ahead and look at them. They're free. You don't have to do anything. I do ask that you like and subscribe just because it makes me feel good. But I've had more than one person call me up and say, God, I don't know why everybody's not on this thing. So, okay. So good. All right. So other terms can have a lot of those things. Advisories, addenda, and disclosures. So the following disclosure, advisories and disclosures are attached. By default, we got the broker compensation advisory, which I pulled up a minute ago, that talks about where commissions come from and all that. But you could have other things, and you want to ask your broker, what that you should include in that. Every broker is different. Okay. All right. Compensation to the broker. So we're going back to answering the stuff that we just filled in up top. The amount of rate is not fixed by law. They're set by each broker individually and may be negotiable between the buyer and the seller. It's a restatement because it's really, remember up there when we were in paragraph number 2, it referred down to this paragraph. All right. Real estate commissions include all compensation fees to the broker and are fully negotiable. I always tell my client I'm a terrible negotiator. This is what I charge personally, and I don't care what other people charge. Not important to me. This is what I charge. I'm a terrible negotiator, and that's why people like to work with me because I'm going to represent you to the end of days. That kind of thing. Whatever your shtick is. Okay, so you figure out what you want that to look like. Okay, all right. But we want to make sure everybody understands the negotiable law. That's why I mentioned earlier, CAR, when they put the forms together, they don't put the commissions in there for you because that would be an antitrust violation, right? That would be telling everybody there's a normal or a usual or a ordinary, or everybody charges this, or nobody's going to show your house without this. These are Sherman antitrust violations. I do a whole class on that, but those are violations that are going to definitely get you in trouble. Do not make those statements. Okay. All right. Broker's right to the compensation. Brokers entitled to compensation above if during the representation period or the extension, remember how we covered that safety clause, protection clause, buyer enters into agreement to purchase or do all these other things, acquire any property that we've described. This is why this is important that we know what we're going to fill in. This is part of your buyer consultation, and the seller thereafter completes the transaction or is prevented from doing so by default of the buyer, right, as follows. So in other words, you close the deal. In California, we say close. In other states, we call it settle. You settle the transaction. You're entitled to compensation. It's usually paid right out of the transactional management program. Okay, so by default, in non-exclusive representation, we need to have broker involvement. And so compensation under non-exclusive is payable only if there was broker involvement with the property. Okay. So if you are in a non-exclusive relationship, then you're going to have to prove up what those properties are. All right. In exclusive buyer acquisition, if the exclusive is checked in 2A2 and initialed again in 15, we're going to get to in a minute, broker is entitled to compensation if the buyer acquires property during the period or any extension with or without broker involvement. You go to the new home subdivision by yourself. This is why I tell you got to have that conversation with the buyer. Thou shalt not go to new home developers without me. Whenever I show property, I pull all the new home subdivisions in the area, and Saturday morning we go out and we look at all of those places. I sign them into every one of them. I'm going to write a book on what can possibly go wrong. If you don't do it that way. But the buyer's going to say, "Oh, I didn't know." Well, they signed an agreement that said that they knew. So you want to make sure you protect the buyer, and sometimes you're going to be protecting yourself at the same time. So if during that period, with or without broker involvement, even if another broker is also entitled to be paid for representing the buyer, we don't want to discount the fact that they may have signed an agreement with another agent. We still are entitled to our compensation, and that's what that paragraph says. So that's why I encourage you, sit down with the buyer during the consultation, read this stuff to them, even if you don't know. Most times people, when they sit down, it's the first time in real estate, it's the first time they've seen the form. When they're coming in from Connecticut, they've been doing this for decades, so they know what this is going to look like. California just writes better forms, I think. So you need to understand the first time you see the form shouldn't be when you're sitting in front of the client. You need to read this ahead of time. And I'm preaching to the choir. You're all here today. Okay. So, but you've agreed to pay me. And even if you've agreed to pay somebody else, you're still paying me, right? Who asked that question? It was a good question. Deborah. Joe, I'm sorry, Deborah asked the question. Yeah, yeah. So you asked, it was a good question. Joe says, should this be a red flag when the lender talks to the buyer? G2. Are you talking about 2G2, Joe? I'm sorry, I missed you. I missed your question. Here's 2G2. Should it be a red flag? Yeah, you might decide you don't want to work with the buyer, right? Your buyer says, I don't have any money, then every offer that you write is going to be predicated on the fact that the buyer does not have the money to pay you. And if the seller doesn't pay you, then you're stuck. And the seller can say no, right? Seller has three choices. One, I'm not paying anything. Two, I pay some but not all. And three, I'll pay all of it, whatever the buyer's asking for. So yeah, you're taking a big chance. Okay, good question, Joe. Sorry I didn't see it. It's in the chat and I don't see the chat. I have to look at it manually. So thank you. Okay, Bob include broker involvement. Okay, we talked about that. So buyer includes buyer, we're defining buyer. Buyer includes any person or entity other than the broker related to the buyer, wife, right? You've had that happen, or who in any manner acts on the buyer's behalf to acquire property. This happens, they end up writing the offer with somebody else through their trust or something like that. But if they're related to the trust, then they're going to owe you compensation. Okay. Broker involvement, wherever used in this agreement means broker physically entered and was shown the property by the buyer, or the broker showed the property to the buyer virtually, not sent them a list, but physically showed them we went through the tour. I wrote it down. We looked at the tour at 12:36 on, Tuesday. So if you write that down, you document it. You're the only one documenting anything in the real estate transaction, folks. You need to write everything down. You need to keep record of what you're doing. You're the only one who's doing it. And in my trial work, I get in there and it's like they've got documentation. The other side doesn't have anything. And so guess what? You're the only one that's got anything to support that you did what you said you did. So there you go. Broker submitted to the seller a signed written offer. So we call that procuring cause, right? And so, there you go. Once they've done that, another agent comes in and tries to do the same thing. They may, depending on the circumstances, may end up having to compensate you. You performed a market analysis related to the property or review specific documents or disclosures, something further beyond perspiration, right? Perpetration, okay? The property is introduced by the broker to the buyer by the broker or somebody operating on the broker's behalf. You did more than just send them a list, okay? So it says right here, merely sending the buyer a list of properties shall not be deemed broker involvement without documented action on the part of the broker analyzing the property for the buyer specifically, right? So this is worth cost of admission right here. Sending them a list is not going to protect you. Okay, all right. Continuation of the right of to compensation for the broker involved properties. So again, you're going to be entitled if the buyer enters into agreement during that continuation period after either the expiration or the cancellation of the agreement, okay, for which there was broker involvement, right? Okay. Broker's right to compensation shall only apply if, prior to expiration, the broker delivers the buyer a written notice of those properties for which there was broker involvement. So you have to give the buyer a list of properties that you've shown them, and that's going to be the notice of broker involved, the NBP and IBP, the notice of broker involved properties. Okay, use that form. I expect to get compensated if you buy one of these homes. Timing of compensation is payable upon completion of the transaction and through escrow or the management that's handling it. And it's going to be whether it closes during the representation period or after the representation period. Some people think I need to get another agreement signed. No, you don't. As long as you entered into it during the representation period, it can close after the representation period. You're still okay. If acquisition is prevented by default of the buyer upon buyer's default. Now the buyer owes you money because they defaulted for some reason, right? They went out and bought the Porsche. Okay. If acquisition is prevented by a third party, this is always good. Party of the transaction other than the buyer, when the buyer collects damages, you are entitled to a piece of the action. And how is that? Shall equal 1/2 of the damages recovered, not to exceed the compensation in 2E1, right? The total amount of compensation, okay? After first deducting unreimbursed payments, et cetera, et cetera. So, I had a transaction where I represented a buyer where they wrote an offer as $1.5 million. They put $100,000 earnest money deposit, and we were the buyer side. And this was before this document, by the way. And the midway through the transaction, the buyer decided to bail. They'd already removed all their contingencies, and the buyer says, "I want the seller to have the deposit." So in my career, I've had three transactions where the buyer gave the deposit, the earnest money, to the seller willfully and just said, "No, I want them to have it." And in this situation, they gave $105,000. I remember specifically $105,000 to the seller because I felt bad. That's what they did. And so I even called their attorney. I knew their attorney. I called their attorney and I said, "Hey, I could get that money back. I mean, that's like," and he says, "No, you don't understand. He wants the seller to have it." It turned out there were other reasons why he wanted the seller to have it, like he was going around me somewhere else and doing a deal. So, that's how that ended up. But I won't give you names or anything, but I remember them very specifically. Quan, buyers often would go to open houses from the list that I sent without me knowing. In this case, will I have to write to compensation if the buyer decides to purchase the house from visiting the open house? And the answer is depends, right? Whether it's exclusive or non-exclusive. If it's exclusive, you're probably in better position than if it's non-exclusive. They could write the offer through the agent holding the house open. But remember that in January of 2008, the NAR changes code of ethics that requires now the buyer, the agent of the open house, to ask the buyer if they have a buyer representation agreement with someone. So way before this rule, they had a rule that said you've got to ask the question, does it happen? Most times not. I had a case that I did where I was head of the professional standards committee at the local level, and we took the commissions away from the agent at the open house and gave it to the other agent, because the other agent was well aware of the fact, the open house agent was well aware of the fact that this person didn't even have a contract with them, but that they'd shown them like 60 houses or something. It was an incredible number. They were well aware of that. They took advantage of the situation. So we don't like that to happen, but every situation is different. Okay. All right. Payment through escrow. We've talked about that. It irrevocably assigns, which means you can't take it back. Once you sign this agreement, it goes to escrow. We're going to send a copy to escrow, and you've given us the right to get paid. Excuse me. Accounting for payments to broker if broker also represents the seller. So if I'm in a dual agent situation, remember they already signed the PRBS form saying dual agency was okay. That's not going to offset the buyer's obligation. There'll be that additional amount of money, whether the seller pays that or not, right? So buyer shall not receive a credit for the compensation the seller owes the broker for representing the seller. You don't get a piece of my action with the seller. Yeah, you don't get credit for that. Okay. All right. Payments received from others for broker compensation. So broker and buyer shall discuss whether it would be beneficial to include a term makes obligating the seller to pay the broker, and that's going to be that what we used to have is the SPBV form, right? Which I think we're going to reinstitute that form in the next thing. That's the seller's payment of buyer's broker's compensation. They're talking about removing 3G3 from the RPA, so watch out for that. The buyer has a right to ask in their offer for the seller to pay the buyer's obligation to pay their broker. Okay. If seller does not pay as contractually required, so in other words, the seller agrees to pay the 3%, but then won't pay it, the buyer assigns to the broker as there's my TPB, third party beneficiary, any rights the buyer has to pursue the seller for that compensation. Okay. And then under the settlement agreement, this refers to Sitzer Burnett. Brokers prohibited from receiving compensation in excess of the amount. We talked about that already. Can't collect more than you said in the agreement. Buyers advised not to include in a purchase offer request the seller pay an amount higher than the amount or as amended prior to the buyer making the offer, which leaves open the window of that we can do an amendment maybe after writing the offer. That kind of leaves that window open, which is, I think we already contemplated that was going to probably be a problem. 15 question. Nope, I got that one already. Okay, good. All right. Disclosure of payments to the broker. Broker going to disclose how much they received from anyone other than the buyer. They have to tell the buyer. They have to be truthful. Cancellation of the buyer representation agreement. We hate cancellation. I'm not going to pull a form up. I do have it in your log, but either may cancel on notice within the time periods we specified already up in 2F. Again, the cancellation form is pretty complicated. You need to read it and make sure you fill it out properly. Broker shall still be entitled to compensation if the buyer enters into a contract to acquire property in which there was involvement, provided the broker delivers to the buyer that written list of properties. We already talked about that. A written list shall be delivered to the buyer within 5 days after effective date of cancellation, even though the language we read a minute ago said before the end of the agreement. And I'm talking to CAR about how they want to handle that. Timing of such payment is subject to the terms above. Okay. Buyer's advised to notify other brokers of the broker's rights. So in other words, the buyer goes to another broker and says, I don't like the broker I signed the agreement with. I want you to represent me. They have to tell the new broker that they have an agreement still with the other broker. And if they don't do that, that's what this paragraph is for. They don't do that, that's on them. They're going to end up with owing 2 compensations. And that was Deborah's question earlier. Okay. Agency relationships. So again, we're into the boilerplate stuff. Disclosure regarding real estate agency relationship. Notice there's no S on the end of it, even though in paragraph 2A of the RPA, it says relationships. I've asked them to change that. The statute doesn't have an S on the end of it either. But these are things I quibble about with the attorneys. So possible dual agency, that's back to my PRBS form again. I don't even know if I pulled that up. You all would recognize it. Here's my cancellation form in case you're interested. It's it's 2 pages. Know what you're doing. Talk to your broker before you fill it out. Buyer financial, we already talked about that. This is my agency disclosure. You always do agency before writing an offer, before representing anybody. You have to disclose the concept of agency. That's Civil Code 2779. Here's my possible dual agency: representation more than one buyer or seller, disclosure and consent. And that's my form number 9. We'll come back to the buyer's investigation advisory here pretty quick, but how am I doing? Yeah, get a little tight. So properties excluded from representation. We already talked about that. You got to tell them which ones. Multiple buyer representation agreements. You're going to inform the broker in writing if you've signed other agreements, just so that they're whether exclusive or non-exclusive. Remember, we may have both, and it could be in a different area. In Deborah, the rule according to Deborah, which is, I like to create rules like the rule in Shelley's case and stuff like that. They could have an agreement with one broker on a specific property inside of Orange County and then sign a second agreement with another broker for all of Orange County. Now you're going to have a fight. So they have to tell you that they signed another agreement. And then at that point, you say, okay, you exclude the property they have that agreement on, right? Like Robert said, that you have an agreement on one specific property, then you're going to want to exclude that property from your agreement. Okay. We don't want to commit to the buyer to paying 2 commissions. So it's important. So buyer shall disclose the broker if another broker showed property virtually or in person. Remember what I said earlier, it's NAR, or wrote an offer on or otherwise acted on their behalf. You may owe compensation if you purchase that to 2 different brokers. If you sign an exclusive with another broker that has not expired or been terminated, you may owe compensation to both. You shall disclose in 2D any properties for which you're obligated to pay another broker. We talked about that. Conflicts with another broker. Buyer acknowledges that the property identified has not entered into an exclusive representation agreement with another broker, has no obligation even under a non-exclusive representation agreement to pay compensation to another broker. So these are questions that we maybe we don't think to ask these questions, but here's a form. If you read through the form, it's kind of like, why do we read you your rights? So that you don't forget something. Right. And so, it's like, because you want to be able to say, I did tell them, I did talk to them about that. I cannot imagine your consultation with the buyer being less than an hour. I don't know how you would do that. Limitation on broker's representation, not obligated to assist the buyer. Buyer shall not owe compensation if it's during the time period, if it's excluded property. And then one of my favorites, broker authorizations and obligations. This is what I'm going to do for you. So broker agrees to exercise effort and due diligence. And this is part of that quid pro quo. Broker will assist the buyer by locating properties, et cetera, et cetera. This is the one I have the lawyers write out. Okay. Selected property, presenting offers authorized by the buyer, assisting buyer negotiating, things like that. Okay. As directed, buyer agreed with the buyer, ordering reports and investigations, right? So like the property ID or something like that. Scheduling, attending meetings, I've got to meet the contractor, things like that. Remember, it's the buyer's responsibility, but the agent, if they do something, they're doing it on behalf of the buyer. So you need to make sure you have an explicit discussion with the buyer about what that looks like. On request, providing the buyer with a list of professionals. I said this earlier, we have an advanced vendor or an approved vendor list. And we'll provide that to the buyer. And again, the buyer's investigation advisory, which is not the buyer's compensation advisory, but I like the investigation advisory. This form is really cool. This explains the importance. And I had to argue with Carr about this because they used to call it the buyer's inspection advisory. And I said, no. The buyer investigates, the agents inspect. Your duty under 2079, Civil Code 2079 says that you will conduct a reasonably competent, diligent, visual inspection of the accessible areas, not an investigation. You as a real estate agent do not have to go in and investigate the property. That's the buyer's job, rule number one, and the buyer has the right to do that. Do not get in front of a buyer who wants to have an investigation done on the property, but they investigate. You just inspect. Reasonably competent, diligent visual inspection. And again, I teach a class on disclosures, and obviously we're very thorough. The TDS takes us like 45 minutes to an hour. So just be aware of that, okay? Let me see, where am I going next? Okay, so flying through here. Upon request, assisting buyer with financial process, of course, and then the buyer, if the property contains a 1 to 4, remember, Civil Code covers residential 1 to 4s. When we get to 5s or graders, we're into UCC, we're into Uniform Commercial Code. The broker will conduct a reasonably competent, diligent visual inspection. I just said this, right? So this is any lawyer, any real estate lawyer you talk to, this just rolls off the tongue, okay? So, I'm limiting my liability, right? I define my duty, I'm limiting my liability, okay? We're going to give you all the information up front, okay? We're going to do our work in compliance with federal, state, and local anti-discrimination laws. Buyer's obligation. So we just talked about the broker's obligation. Let's talk about the buyer's obligation. You agree to negotiate in good faith. You're not just having me taking you on a car ride, right? And you're going to negotiate in good faith to acquire property and complete the contract. Okay. Financial and personal information. So we've talked about this already. I kind of dug deep into some of this stuff. So if the buyer fails to provide the information, then the broker may cancel the agreement. It's that quid pro quo again. If the box is checked in 2G2 for any which a buyer writes an offer to purchase, buyer agrees to include a term in the buyer's offer requesting the seller to compensate the buyer's broker. Okay, important. All right. For a transaction, this agreement is contingent upon the seller or others agreeing to pay that compensation. If the seller doesn't want to pay it, the buyer doesn't have to do the deal. You got to understand that you're giving the buyer a way out of the transaction by having an agreement that says that, I don't have the money, and if the seller doesn't pay me, I don't have the money to pay you, and so it gets me out of the deal. Okay, I got into an argument with an escrow officer the other day over enforceability of. It was interesting. Somebody giving me legal advice about the contract, and I don't give legal advice. I couldn't imagine why they would be giving me legal advice. But anyway, whole other deal. Okay. Reasonable care and other professional assistance. This is on the buyer now. Okay, buyer's obligated and agrees to read all the documents provided to the buyer. How many times have you had a buyer say, "Here, I'll just sign it"? Right? Oh, that's very dangerous. Okay. You want to make sure that they understand what they're signing, that they've read through it. We'll see that at the bottom of our form here in just a minute. So buyer agrees to seek desired assistance from appropriate professionals. Again, it says that in the buyer's investigation advisory. Buyer's advised to read the investigation advisory. I always love it. Well, I've never read it. I love it when they go to court, they say they didn't read it. And the judge says, or the attorney says, "Is this your initial at the bottom of the page?" Well, yeah. Okay. Well, then you read it, right? Or you had the ability to read it even after you initialed it. So buyer agrees to pay for reports, investigation, etc. Buyer material issues. One of my favorite forms. Nobody ever uses this form. I love this form. You need to be using this in your transactions. So that's this form right here, my buyer material issue form for a specific property. And I never see this completed. And yet I don't know today why you wouldn't. and you send this over to the buyer. You tell me what's important to you in the purchase of the home. And if they put in there school districts are very important, that doesn't mean you're going to guarantee school districts. It just means you need to make sure they've got lots of information that they can make their own decision about the school districts. Okay, so they're telling you ahead of time, this is what I'm gonna come after you for. All right, good. Okay, so I like that form. I think it's a great form. I don't see people using it. We require it. So incomplete, you give me bad information, your bad intel, as we always said, then you're going to be liable for that. You're going to absolve me of any claims. Attorney's fees provision. This changed, and I love this, the way they've done this. So each responsible for paying their own attorney's fees and costs. And that was written by the attorneys at CAR to try to reduce the amount of litigation, right? So why? Because, these attorneys get these fees all jacked up and all that kind of stuff. And then the only one that wins are the attorneys. Well, how about if each of you pay your own? I don't care if you hire I have a transaction, $1,250 an hour attorney. And it's like, why? Okay, well, maybe they're really good. I don't know. They're getting away with it. But anyway, each party pays their own. That's a big departure from the way our agreement used to read. Here's that management proposal I was talking to you about earlier. If an associate licensee in the broker's office, other than the broker, obviously enters in the agreement on the broker's behalf, the broker or manager has the right to cancel the agreement in writing. Nobody knows this. Okay, remember the DRE requires that you get everything in front of your broker, anything material to the transaction within 3 business days. That's a DRE requirement. Not like in my when I was management with the rock people, they would come in my office. This thing's closing tomorrow. I want to make sure I get paid. I said, well, where's my file? Well, here it is. And it's like, that's not, first of all, it's not a file. Secondly, you're handing it to me the day before closing, and I no longer have right by contract to cancel a bad agreement that you made. So, I get into a fight with people, over we're not going to pay you. And so, that kind of thing. So, but I've got 5 days. I don't not pay people, by the way. I rarely ever had, I only had one person I ever had to just stop doing that because they were coming into my office the day before closing. It's like, I don't want to hear it. You need to give this to your broker within, DRE says 3 days. Your broker may make that time shorter. In our office is 24 hours. We, email, whatever, Dropbox, whatever. Okay. All right. Dispute resolution, one of my favorite subjects. So we have mediation. So, we all agree to go to the mediator and try to work things out. Okay. Mediation tends to be non-binding. However, if everybody agrees to the terms in the mediation, the mediator will draft up an agreement for everybody to sign. Now we have a contract, and that now it is binding mediation. Okay. There are going to be some exclusions to, oh, by the way, if you skip mediation, you may end up having to pay the other people's, if the other people win in trial, they don't get their attorney's fees. So it says right here, prevailing party shall be entitled to recover attorney's fees from a non-prevailing party. So, and then we have additional mediation terms. Again, these are things your buyer needs to be reading. It doesn't apply to foreclosures, doesn't apply to unlawful detainers, things like that. Arbitration advisory. So we took these out of the employment agreements because the brokers were saying, we don't want our agents committing us to arbitrate. We want to go to court, right? And so they asked to get that taken out of the agreement. So let me show you that. Here's the arbitration form. And the arbitration agreement, again, check with your broker if your broker wants you to use it. It is still in the purchase agreement. It's just no longer in the employment agreement. So between the buyer and the buyer's agent and the seller and the seller's agent. Okay. Wow, we're doing pretty good here. Elsie, how am I doing? I'm doing okay. I got a couple minutes. Okay, so that's that form. Legally authorized signer. And so again, legally authorized signer, the party, they affirm up front that they have the ability to sign the document on behalf of either themselves or the third, a trustee or, their trust or whatever. This is a very important thing. I mean, they're saying right in the document that they have the ability to do that, whether it's a trust cert or the statutory agent or whatever. And they agree to give you a copy of that document. This is the entire agreement. It's standard language. This is the agreement, the whole agreement, nothing but the agreement. So help me God, that kind of thing. Will we be getting the recording? Daria, Yes, I'm pretty sure that OCAR is going to give you a copy of this recording. And again, I'm always available to help you if there's anything I can do. This is the entire agreement. You know, anything you say is not part of the agreement. Exclusive, we've got to have them check this box if we, or I'm sorry, this is what, remember we had to come back to this paragraph 15 from earlier. And this is just restatement of what it was before the buyer initials this. If they don't initial this and you checked exclusive, it doesn't apply. You need to make sure that they initial if they wanted exclusive to apply. And now by signing below, one of my favorite things, they acknowledge they've received a copy. They have read, understand, and agree to its terms. Because we had a lot of times people say, I didn't read it. Well, now you signed a document saying that you read it. For an entity buyer, and I was going to show you how to do this, but I'm not going to have enough time. But go to my YouTube station. I do a whole thing on how to get all the names to line up on the document by going to the parties section of your zip forms, for example. Pretty short little YouTube video on how to do that. And then I also have, I know I saved some stuff for here for today that I'm not going to have time to get to either, that I show you all kinds of little tips and tricks. And so I want you to know how to do that. I do have some instructions in the ancillary document that OCAR is going to send you that show you how to do some of these things, okay? I want to make your life easy. If you use this form properly, then you don't need to have a separate RCSD, okay? Non-individual entity buyer, so non-natural person, trust, corporation, LLC, holding a power of attorney, those kinds of things. Full entity name. And again, if you go look at that YouTube video, or I'm sorry, you look at these ancillary documents, you'll see instructions on how to fill this out. Contractual identity of the buyer. I want to see their full name. If it's a trust, you know, give me the full name of the trust. If it's sold under probate court, legally authorized signer. So it's being signed by someone who's signed. Obviously, an entity doesn't have the ability to sign anything. So we have to have somebody else authorized to sign on behalf of the entity. And so here's the name of that legally authorized signer. Buyer signature, sign, date, printed name of the buyer. If you fill out zip forms properly, it'll already be in there. Printed name of the legally authorized signer. Excuse me. And then here we are again. This is a repeat. Question one, is the BRBC contract enforceable if the buyer forgot to initialize at the bottom of the pages? So that's a question of law, whether or not it's enforceable. Typically in our agreements, the initials at the bottom of the page are not part of the binding part of the agreement. The binding part of the agreement is the signature. The initials at the bottom of the page indicate that they have seen the page and that they've got hopefully a copy of it. So, so to answer your question, you'll have to talk to a lawyer as to whether or not they're enforceable, but that's just the principle is that initials at the bottom of the pages don't really mean anything unless it's a separate initial like a liquidated damages or an arbitration. So good question. Thank you for that, Quan. Good. You're asking good questions today. I might send you to law school. Let me see here. Oh, thank you, Jim. No, thank you. That's very kind. Okay, let me see. Additional signature addendum. So that's if you're going to have more than two people. And again, we have that form is up here. There's my additional signature addendum. And again, this is a new form. Sorry, it's a revision of the old form. I like what they did to it. And this is what you're going to do if you've got more than two signers. Okay, all right. And then I'll just fast forward. The additional agent acknowledgement is the form that we use whenever more than one agent within the same brokerage is going to be acting on behalf of the buyer. And MRS, oh, thank you. You're so kind. Yes, please stay connected with me. And your broker's an amazing person. So good. Thank you for that. Thank you very much for that, Amaris. But I am here to help you. I want you to be okay. I just had a thing going with another broker recently who told their agent, you know, whatever Kevin says. Now, I don't think I'm that good, but they know me very well. They've known me for decades. Before they got a broker's license, and they said, no, Kevin says it, it's true. So, you know, that's a high standard for me to have to maintain. Okay. So additional signature addendum, broker signature. Here it is, DRE license number. Here's the agent signing on behalf of the broker. And here's my ABA form, I'm sorry, my AA, which is more than one agent from the same firm. Here's my ABA, which is we're going to have two brokers. I'm going to tell you that check with your broker before you agree to co-list a property with a different brokerage firm. It can tend to be fairly problematic. Got recent experience with this. And so you want to figure that out. Check with your broker for sure. Be very careful. Thank you, Joe. Thank you, Jim. So be very careful, folks. Do not sign agreements with other brokerages unless you have your broker's approval. Be sure about that. That's the form. Do you feel better? That's my whole thing. People are starting to drop off already, but do you feel better? I want you to feel good about this because I don't think it's that onerous. We covered all the meat and potatoes of this, right? Remember, Wayne Bell, when you define your duty, you limit your liability. Feedback, suggestions, please let OCAR know. Let them know. Oh my God, this guy was horrible. That Mike Ferry, don't say that. I'm just kidding with you. But let them know if you want me to teach other things. I do disclosure classes. I do all kinds of stuff. And whatever you put in your feedback, they read each and every one of those. Quan, will you have a class on the RPA? One of my favorite documents. And I get RPA. I was RPA approved by the Department of Real Estate. I'm happy to do it again. The RPA, I love the RPA. It does not say what you think it does. But I have not been asked here to do a talk on that. But I would love to do the RPA and the RLA, frankly. So again, put that in your feedback. When they send you the feedback form, you do me a big favor by actually completing the form. Okay. Any of my previous webinar videos, here's the QR code that'll get you to that. You just click on it, or you'll get a copy of all this. Or you can go to @Burke Real Estate Consultants Inc. Remember to like and subscribe. And thank you again to Orange County. I mean, your association just knocks it out. They allowed me to do this presentation. I do have a newsletter. It goes out once a week. I'm very careful not to. I do not put people on the list unless they ask me to put on it. So definitely, if you want to be in on that, thank you. Thank you. Yes, I feel better. Oh, goodness gracious. Oh, yeah. Upcoming cloud. Thank you. OCAR put up upcoming classes. Oh, that's cool. Yeah, I'm excited. Listen, give me in front, give a lawyer a microphone. You're saying, Ethan, you're so funny. Yeah, I feel better now. Okay, good. Thank you for that. So, and thank you for OCAR, Elsie, of course. I hate to say, go without saying the name, but she's wonderful. Go Tritons. Yeah, UCSD. That's where I teach my law class. So yeah, I teach the paralegal program there, and it's been very good for me. 25 years. Can you believe it? They told me they were looking for another instructor. I don't think they're still looking. And then finally, thank you again. This is my contact information. I want to help you. I want you to be successful. I want to take credit for making you a multimillionaire, whatever it takes, but you got to ask. So thank you all for being here today. And thank you again to OCAR for allowing me to go over by 2 minutes. I apologize. Let me make sure there's nothing else in the chat. Appreciate your time. Thank you, Deborah. And Henry, I definitely feel better. Thank you. Yeah, and OCAR is going to put all this up on their YouTube channel. Listen, you need to watch this. You might have to watch it again. You need to be the best you could possibly be. Don't worry about what other people are doing. Worry about what you're doing. My first 5 years in real estate, I was doing everybody was saying, how do you do all these deals? I said, I thought everybody was doing this. So listen, I wish you tremendous success. Thank you very much. Have a great day. And look forward to seeing you out in the world. Take care for now.